Yeah. 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 For posting on why? What is no final hearing? You want final hearing? Please file an application for early hearing. This can't be. Early hearing is not being listed. See, Mr. What is it, madam? Hey, Mr. Natrasi, what is it? MFA, what? What is the urgency?
Vacating application. Vacating application.
Vacating stay. What?
What is that? ಏನ್ ಆಗ್ಬೇಕು madam ಅದರಲ್ಲಿ?
Take it. Give it to his lordship. Yes. Yes. Compromise. When do you want? When? Monday. Yes, madam. Monday.
Vacating.
So what? Vacating stay.
After 2 days.
So,
Friday after test. Right.
Friday.
Friday.
This one. Yes. Day after. No, you want final hearing, madam? Then please move an application for urgent hearing. By way of this memo, we cannot dispense with the requirement of filing an application for early hearing, right? We will allow that and fix a date. That's what we told the other council also. You can't, I mean, like this tomorrow for final hearing. Can't do like this. Yes. You want to withdraw? Then wait. Memo of retirement on whose behalf is accepted, permitted to retire. Yes. Office is directed to delete the name of Mr. G. Ravishankar Shastri. Right? And what's your name? And to reflect the name of Mr.
Artist name has to be. Artist name has to be.
Party's name?
Is Ravishankar Shastri.
Oh, achha, you have filed a memo. Oh. Why? Absolutely nothing. So, permitted to retire. Should we what?
We'll give a date and
let the appeal be listed after 1 week.
date will be
Then notice has to be issued.
not necessarily. You have issued notice to the issued already.
15th March. List on 15th March. Yes.
For the appellant in this case, my lords, I pray for 2 weeks accommodation. I'll take steps for the respondent.
Number 3, the agreement letter. Number 4,
Your Lordship, I appear for petitioner in this case, serial number 4, Your Lordship.
What is the memo this?
Non-compliance of office objection memo. Delay of 88 is IA 1 of 70. Taken up. Delay condoned. Yes.
Lord, all this
with the previous item 4. Yes, Mr.
serial number 5, Lord, all these matters. Lord, I am appearing for the contesting respondent in these matters.
Yes.
Lord, we have filed the early hearing applications, Lord. It has been coming on this consideration of the year. And understanding was, Lord, the matter has to be heard.
Who entered into an understanding with you?
In last date of hearing,
No, we are allowing
both of the councils,
whatever be there on record.
councils.
We will allow the application. No understanding. Heard on. All right. Just 5. Heard on IA 1 of 20. Application taking into account nature of controversy involved in the appeal and for the reasons assigned in the memo. In the application, IA 1 of 20 is allowed. When, madam? Tell us. Yes, Mr. Which date? 22nd March. 17th we have 22nd or 23rd March. 23rd March. 2022 5.5 heard on IAS 1. So 5.6. Oh, yes. Heard on IA 2 of 20. Delay of sufficient cost. Yep.
Number 6, J. Kumar K.
Notice on IA.
Notice is already ordered. Yes, right. Furnished.
Oh, furnished. You have to furnish process fees.
You have to pay the process, Mr. Notice is already issued on the IA.
2 weeks time.
Yes, let's do that.
How much?
Without service of notice. Without service of notice, how delay can be condoned?
Next steps in addition. Permitted to serve in addition, right? You take steps for service.
7, the Murgeshri Charity.
Weeks.
Number 8, the consulting government certificates.
2 weeks. Day before yesterday.
Covered.
Ah, covered. Yes. Ah. 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 Oh, this is that Arkavati layout, is it? Shivram. So then approach, you want to approach the committee, do it, but this validity of this notification has been upheld, right, Mr.? You can't dispute, and this section 19 has also been upheld. Right? Virus of section. Similar order. We can't take a different view, right? You will agree that if we are wrong, that we are consistently wrong, right? You can't take a deviation in your case. Also, that committee will consider, fine. That we will say. We will say that your representation will be considered. No, nothing. No, nothing can be. No. File a suit, do whatever you can. But this view, I mean, there has to be finality of litigation. How can no? You have no option but to agree. But if you don't agree, then we don't. No, Mr. You have challenged. Please understand. You have challenged the validity of section 19 and final notification. Both of them have been upheld in previous rounds of litigation. We cannot. What basis do we grant stay? Please understand. We already see a queue outside the court. One case we grant stay. What basis? What basis? We don't know. Demolition. You approach them. Approach committee. Do whatever. We will not intervene. No. Oh, it is for them. So it is for the committee to decide, right? Who there? Ask them. Yes. In this writ petition, where is the order? Which page, Mr. Reed? Order by the learned single judge. Which page is the order? Oh, writ petition. Fine. All right. Sorry. Writ petition. In this writ petition, the petitioner has prayed for the following release paragraph. We have heard learned counsel for the parties at length from validity of the. We have heard learned counsel for the parties at length. Validity of the Bangalore Development Authority Act 1976 has been upheld by Honorable Supreme Court in Offshore Holdings Private Limited versus Bangalore Development Authority and others, 2011, Volume 3, SLC 139. Therefore, the challenge to Section 19 within bracket 1 of the Act cannot be entertained in view of law laid down by Supreme Court in so and so versus so and so, 1989, Volume 1, 1989. Supplement 1 SCC 151 or whatever. 151 is the page. I'll tell you. It is also pertinent to mention here that the validity of the preliminary notification in respect of scheme in question has already been upheld by Supreme Court in Bangalore Development Authority versus State of Karnataka and others, 2018, Volume 9, SCC 122, as well as Division Bench of this Court, White Orders dated 22/12/2021, passed in WA number 1363/2021 and WA number 1400/2021. Full stop. In view of, for the aforementioned reasons, we do not find any ground to entertain the writ petition. However, it will be open for the. However, the petitioner is granted the liberty to approach the committee which has been constituted in pursuance of the order passed by the Honorable Supreme Court. Honorable Supreme Court with regard to his grievance. Grievance of demolition of the construction raised by the appellant. Grievance, that's all. Let's leave it there then. Grievance. Accordingly, the petition is disposed of. Yes. You should have produced it. We have now an order has been passed. This is all defeating the order, and the validity has already been disturbed. Are you not? Don't understand. Once the validity of the notification having been upheld by the Supreme Court, on what basis can we grant stay? We don't know. Please, I mean, you know, what is it? So then, go there. You have rightly pointed out. So, Supreme Court alone can do. If Supreme Court can constitute the committee, Supreme Court can grant stay out. We can't grant it. Our decisions are binding, Mr. So please understand what. No, Mr. We told you that if we are wrong, we have to be consistently wrong. In the other writ petition also, we have not entertained, it has been dismissed. We have given numbers. You tell us any order passed by this court where we have granted protection. We don't know. So it is open for you. It is expected that the committee shall, yes, madam, right, thereafter open to so a grievance. It is expected that the committee shall consider the grievance of the petitioners expeditiously. Accordingly, petition is disposed of. Yes.
Number 9, the validity.
Repeated challenges. Everything done.
That's an order.
My petition has not been decided. We will say that it will not decided. Yes. You have to. Yes. What? Certified copy of Annexure C you have filed. Learned counsel for the petitioner submits that he has filed certified copy of Annexure C. What office objection? 2 of 20. Non-compliance. What is matter? Yes.
I appear for respondent number 2, my lordship.
So let office objections be complied with within 1 week. Yes. What? Let us say something.
That have filed IA for modification of entry holder, my lord.
Matter. For the
Second respondent.
respondent. Yes, ma'am. Second respondent.
Second respondent.
What? Yes, madam.
This
So
honorable
it is
court
for
has
office
directed.
Tell him the matter is listed for
Yes, my
office
lord.
object.
I will verify and I will comply.
Please comply. Yes. Which force?
That application has been returned, madam. There is office objection in that.
In fact, my lordship, may I make submission, my lordship?
You take it up Monday, Tuesday, whenever you want. Let us. Office objections be complied with. Say list for consideration of IA. Application for modification, right? List for consideration of IA. That will comply. They will. 2 of 21 within on 15th March. So whatever objection is there, please. He is probably unable to hear us.
Please, ma'am.
No urgency. This is office objection, right? It has not come up on any other application. It has come up, please understand, it has come up only for office objections. If there was an urgency, you would have given a mention memo. Nothing prevents you. The matter is, we are fixing it for Tuesday only.
There is office objection even in respect of that IA.
Yes, my lord.
Please see the cost list. In both the applications, there are office objections.
Yes, my lord.
Please part.
I will comply, my lordship.
Please comply. Yes.
Comply, my lord.
My lord, in this matter, I am appearing for the petitioner. My lord, the respondent 1 and 2 have not gone there and ascertained the whereabouts of the child. The father has avoided the service of summons, my lord. He has tried to maneuver it. My lord, the state government.
You are the wife, right? Husband, wife. No, the child is safe. There is no harm to him. He is safe. The question is of custody, habeas corpus.
My lord, my child's examination is on 22nd. My lord, the mother is before the court. My lord, my colleague is also before the court. My lord, child's examination is on 22nd of March.
What? Respondent number 3 has not been served.
The father is avoiding the summons, my lord. I don't mind taking further steps, but the police have not reached their counterpart at Delhi, my lord. He is in illegal custody. He takes the child under the pretext to show to the
No, but he is safe, right? I mean, there is no threat to his life, except the fact that you want his custody. That's all right. But there is no imminent threat that he is kidnapped and he would be killed, or some 25 lakhs is being demanded from you. Not a case of that type.
Not like
right?
that.
The dispute between parents, normally we are dealing with these issues.
No, my lord,
But
what
the
has
fact
happened
remains
is,
that you have to, please, Mr. Respondent number 3 has not been served. We can't do anything.
my lord, what has happened here is,
You have to
my
take
child's
steps.
examination is on 22nd of March.
Which examination? 12th board. 12th board.
No, he is in
Then-
Delhi Public School. Is an annual
Which
examination.
class?
My
Which
lord, he
class?
is in 7th. My lord, he is in 5th standard. My lord, a young boy.
50. So what? Please understand, Mr. We are trying to tell both of you. Please understand. You are lawyers. No? The respondent number 3 has not been served. How can we pass an order directing custody to you? You want that right away. He should be, respondent number 3 should be hanged and custody should be given to you. Can we do it? No. Respondent number 3 is your husband, right? Then where is he? What does it mean? No, we don't know this. We are not pleading respondent number 3's case before you. Please understand. Don't be under this impression. You have not been able to serve respondent number 3. We are asking you what can be done. You have to take steps. He's saying police has not gone. What is the material? We don't have any means to ascertain. Police has gone. File an affidavit. Not gone and not served. He has to be served, right? Before we can proceed in the matter. We, at your insistence, we will not pass an order which will be set aside in 1 second by any court. We have directed issuance of notice. You have not served.
My lord, emergent notice.
Is this for office note? You are arguing everything except what steps have you taken, Mr. D? What steps have you taken for listing of the matter if the examination was 22nd March? It has come up on office note, not at your effort. You did not make any effort to get the case listed. So that respondent number 3 has not been served. What can we do?
My lord, 10 days may be posted. May I take emergent notice, my lord? Kindly oblige.
He has understood now.
No. I understand the mind of the court, my lord.
What can mind be? This is the procedure. No, I will not. No. Supposing if you would have been counsel for respondent number 3, what you would have told your client?
I will certainly not debate.
What sort of an order the court has passed in violation of natural justice without serving notice to you? That's what you would advise, right? Please take steps. You take steps. We will fix the date on which you want, but we can't proceed in the absence of service of notice. You have to take responsibility.
Emergent notice last week of this month, my lord.
Issue emergent office report furnishing. Sir, they have not furnished.
They have to pay.
Already emergent notice is issued.
Counsel for the petitioner undertakes to pay fresh process fee within today
24
during the course of the day. On requisite being furnished, issue emergent notice. In addition, what?
My lord, police may be directed to ascertain.
UP. So what a UP means? You don't have jurisdiction over UP, right? When do you want, Mr. Tell us it. We can't
List immediately after service.
list immediately as soon as respond number 3 is served. Whenever it is served, please take steps.
Oblige.
Today, sir.
I appear for the appellant in this matter, Your Lord.
He is standing. Therefore, is under pressure. Yes.
I appear for the appellant in this matter, Your Lord.
Yes. So what objections have been filed?
Some disturbance in this. There's some disturbance.
That's what. Yes. No, who appears for respondent?
A.B. Ramananda appears for the respondent in this matter.
What here? Yes, filed objections to your IA.
No, Lord. It is not filed as appears for the
Not. What? What is he saying?
There's some disturbance in the audio. There's some disturbance in the audio.
Yeah, one of 2014 as well as one of 21.
I am appearing because there was some communication. This thing. I am appearing for the respondent in this matter. By the connected matter also, I am appearing with the appellant, my lords.
Matter.
I could not hear it.
13.
Oh, sorry.
Oh.
Serial number 13, I thought. There is some communication.
13. No?
In serial number 11, I appear for the appellant in this matter, Your Lords.
Fine. So objections have been filed to your IA or not? We will grant them a week's time. Let objections, if any, be filed to IA one of 2014 and one of 21. So within 1 week, list thereafter.
Number 12.
My lord, in this case, I appear on behalf of the appellants, my lord. There's a condemnation of delay of 84 days, my lord.
Sufficient. Taking into account the fact expression sufficient. IE is allowed. Appeal is what admitted for hearing. Issue notice. We have admitted your appeal for hearing. Delay control.
Much obliged, my lords.
Number 13. Sri Ravishankar Shastri, Sri Vipin Hegde,
What office?
Appeal for the appellant in the connected matter, my lords, 13.1. I had to put the death certificate, my lords. Actually, they are brothers. Both the brothers have passed away. They have to bring the LR's record. I had to bring the other appellant's LR's on record. I got the death certificate only yesterday, my lords. I'll just give me lordship, may give me 1 week's time. I'll furnish the death certificate, my lords.
So 13.1. The appellant place for is granted a week's time to enable him to place on record death certificate of appellant.
No, respondent, my lords. Appellant also is dead. I already produced the certificate. Respondent, my lords. Second respondent.
Respondent number.
Prafulla Shetty. He is the appellant in 13, my lords. In 13.1, he is the respondent.
In 30. Shall praise for is granted a week's time to enable him to comply with office orders. Right? You have to file substitution, something like that.
Yes, already filed.
Filed. Okay. All right. Please, yes.
Much of
Number 14. Sri Nataraj Ballad.
Clear. Oh, it is to Nataraj Ballad. The memo has been filed so and so permitted to retire from the district, heard on IA 1 of 22. We'll have to fix a date, right? And notice also, no? Otherwise, then again, recall and all that.
There is some other advocate. Now somebody is appearing.
Some R. Gopal is there.
Now Arun Sham. Now Arun Sham also has filed an memo.
Issue notice. All right, issue notice.
Yes, somebody is there.
You are appearing. You should tell us, no? You have filed a memo for retirement. No.
You are appearing on behalf of which advocate? Arun Sham, you have filed a memo for retirement. Yeah, only filed.
Issue notice. All right, all right. Now, appeal is admitted for hearing. Issue notice heard on IA 1 of 2022. Nature of controversy, taking into account the fact that appeal is pending since 2016. IA is allowed. Let the appeal be listed for final hearing on 4th of April 2022. Yes. No, otherwise, again, they will file recall and all that. To be on the safer side, I mean, though it is not necessary.
All the three matters.
All three.
Yes. 14, 14.1 and 14.2.
Number 15. Sri Dilip Kumar, Sri Vishwanath Shetty.
Still
Not pressing appeal. Okay. Mark the presence. Learned counsel. The appellant has filed. What? Not pressing the appeal. So you want to withdraw the appeal? So what happened? Has filed a memo seeking leave of this court to withdraw the appeal itself on the ground. No, does not want to. Learned counsel for the appellant seeks leave of this court to withdraw IA number 1 of 2019 and 2 of 2019 on the ground that the matter has been amicably resolved between the parties. In view of the aforesaid memo is taken on record, IA so and so is dismissed as the party.
Number 16. CT Nataraju, NT Gita Devi.
1 lakh. Who has to deposit 1 lakh? Dismiss the record that. We'll discuss for that.
No instruction.
Yes. Learned counsel will dismiss matter. He is saying no instructions. Learned counsel for the appellant submits that he has no instructions to appear in the matter. After presence, learned counsel for the appellant submit no instructions to appear in view of Afforces submission is taken on record. Appeal is dismissed for want of prosecution.
Number 17, Parameshwara Pasi, Sri Rajendra Desai.
Well, we thought that you have filed this thing.
No, any of the matter is listed on 14. Therefore, his name will be shown on that day. If he has filed work.
4th April. All right, court notice not necessary. He appears. And then who is permitted to retire, Mr.
Arun Sham.
Arun Sham is permitted. Mr. Arun Sham is permitted to retire. Yes.
17, Sri Parameshwara Pasi, Sri Rajendra Desai.
Seeks leave of this memo. Amicable settlement. Why do you want to withdraw? Don't know. Oh, by the memo, seek leave. You don't know. All right, seek leave of this court to withdraw the appeal. The memo is taken, dismissed as withdrawn. Fine.
Number 18, Sri Nanjareddy PM.
And I appear for the appellant. There is a delay of 50 days in filing the appeal.
Heard on IAS. Kandur, IAS allowed. Admitted for hearing record.
Number 19, Sri B.B. Shivkumar, Sri Prasanna Kumar.
What happened? Mediation failed. Have you responded to this IA1 of 2019? Sir, whether means we can't take it up. You will have
That
to file
revision is
an
before the single.
Yes, Mr. Okay, 2 days time. All right. Learned counsel for Mr. V.B. Shivkumar, learned counsel for the appellant. Mr. P. Prasanna Kumar, learned counsel for respondent. Learned counsel for the appellant submits that despite an order dated 16/9/2018, 26/9/2018, directing the respondent to pay the fee, tuition fee, right? Tuition fee of the child, the same has not been paid in lieu of aforesaid submission. Learned counsel for respondent prays for short accommodation to enable him to make a statement in this regard. List on 16th March 2020.
Number 20,
Yes. You right. What is it? What is not there?
It's called my land.
All when? Not there.
Not
right. Order, which order, madam? Date? Last date. Acha. Yes. Despite order dated 22/2022, the record of the proceeding before the trial court have not been received. Office is directed to issue a reminder and let the appeal be listed for orders on the interlocutory application immediately after receipt of record.
Appearing for appellant in this
Yes,
matter.
sir. Yes.
Filed the application for earlier hearing.
Heard on IA 1 of 22, taking into account list on 11th April 20. IA is allowed. Let the appeal be listed for final hearing on 11th April 2022. 11th April.
Much obliged.
My lord, I am for the respondent number 1, my lord.
All right, Mr.
My lord, I am for the respondent number 1, my lord. Case is posted for Lok Adalat on 12th, my lord. After 12th, any date may be fixed, my lord.
Counsel from the party submit. He is permitted to Mr. Venkatesh P. Dalwai. We have asked you to assist in one case, right? You got the. We hope you got the paper. Fine. Probably it's coming up tomorrow or day after, whatever. Yes. So, the Red Counsel for Respondent submits that his office is directed to delete the name of Mr. Venkatesh P. Dalwai. Mr. K. N. Sanjay Kumar, Learned Counsel for Respondent number 1, submits that the matter is fixed before the Lok Adalat. He therefore prays for adjournment. List after 10 days.
Yes, madam.
23. Here, Gopal Soni.
Furnishing. Furnished. Then, how much time? During the course, undertakes to comply with office objections during the course of the day. On requisites being furnished, issue notice of IA 1 of 18, 2 of 18 to respondent. Dispensation on IA 1 of 20. Requirement of translated copy of documents and extra dispense with IA is allowed. Yes.
Number 25.
1 minute. Oh. All right. Learned. Dispensed with. Also, all right. Learned Counsel submits at how much time, man? Place for is granted 2 weeks time to enable him to place on record the translated version of the impugned order.
IA 1 may be dismissed as not pressed.
IA 1 of 22 is dismissed as not pressed. Yes. Liberty to serve a copy. To Learned Counsel who served who appeared represented the respondent before the learned judge.
Number 25.
Service awaited. Await service of notice on respondent number 3. This immediately after respondent number 3 served.
26.
Publication IA for substituted service. Notice be published in daily. Which paper, Mr. Natas?
Which newspaper?
Vijay Karnataka. Which edition? Bangalore edition. Bangalore and Mysore rural edition for appearance of respondent before this court on 12th of April 2022. Accordingly, IA 3 of 22 is allowed. Or it could be after this thing also. 19th of April. 19th of April 2020. IA is allowed. Yes.
Number 27. The Madanagowda head.
All right, yes. IA 2 of 21 is dismissed as withdrawn. Heard on IA 1 of 21. Issue notice to respondent.
Number 28. The Muhammad Mujahid. The Ranaka.
No, 2 and 3, they are not served.
Wait for yesterday, we were fast in order. Request. That matter like this attachment order is passed.
She wants to let it be passed over. She wants to file something. Learned additional government advocate undertakes to file praise for adjournment to enable her to file certain documents on record. Nobody is disputing that in public interest litigation orders have been passed. But he has a statutory right of appeal that has to be examined independently. That's fine, we will take into account. So when do you want? Day after tomorrow? List on day after. 11th March.
29.
Interim order. Now finally it has come. Yes. So, again.
Yes, interim order continue.
Interim order shall continue. Yes. Where is the calculation which you had given? Mr. G. Krishnamurti, learned senior counsel with right her name. Mr. Madam for learned Mrs. Vani, learned additional comment advocate, correspondence number 1 to 3. Mr. B.V. Srinidhi, learned counsel for 4 and 5. Heard on the question of interim relief. Learned senior counsel for the petitioner. The learned counsel for the petitioner submits that learned counsel for the petitioner submits that an amount of how much? No. Total amount.
146.
A total amount of please amount 1 crore 40. 18,307 is being demanded from the petitioner by the BBMP under various heads. It is submitted that levy of scrutiny fee, ground rent, license fee, security deposit, lake rejuvenation fee has been quashed by this court by order dated 4/8/2021 passed in WP number 4601/2020 and other connected matters. It is also submitted that petitioners are ready and willing. It is further submitted that levy and collection of BWSSB, improvement of levy of fee on account of BWSSB, ring road, improvement of slums and mass rapid transport system has been stayed, right? Has also been stayed by this court in several writ petitions, namely WP number 12373/2020 and other connected matters. It is therefore submitted that petitioner is betterment charges you have written, right? Page 7. Page 7. It is also pointed out that betterment charges for the site and betterment charges for building, levy of levy of betterment charges for site and betterment charges for building has also been stayed by an interim order passed by this court in WP number 13000/2020 and WP number 7203/2021. Paragraph, it is further submitted that the petitioner is ready and willing to deposit a sum of ₹50 lakhs subject to result of the writ petition, and the respondent number 4 and 5 be directed to do what?
Issue sanction plan and commencement.
To issue sanction plan and commencement certificate subject to further orders which may be passed in this regard.
Only because tomorrow if they sell the property or encumber the property, then we will have to pay. Earlier what we have said is
For the yes, so and so in addition, the petitioner shall furnish an indemnity bond to secure the payment of remaining amount in the event of failure in the petition within a period of 1 week. No, this is not deposit, right? We'll see. You have 50 lakhs. Of course, 50 lakhs. I mean, if you are held entitled to refund, then you will be liable. You will get interest. What rate you find out? 6% or whatever. Yes, Mr. Madam. Yes, heard on IA 1 of 22. In the beginning, you write, taking into account the nature of proposed amendment and for the reasons stated therein, same is allowed. Let amended petition within 1 week. Well, that is up to you, right?
1 week, we said.
It is up to you. We have not fixed any time limit for issuing this thing. So you do it after furnishing. That is best. But his client has been good, right? No, 40 lakhs, 46 lakhs, he is giving you 4 lakhs more.
No.
We don't know.
It's a consent order. How can it be president? No.
All right. Yes. Ah. 50%. Yes, Mr. Singh. What is? Oh, he was right. Mr. Srinidhi was right. That lumber.
That is by the association. That is by the association. Association, by the association.
Association, right? Association has also.
Ultimately, it is the bidders.
No, you file objections. We will hear it before others can come. We will before others. This thing we let's decide. Please file whenever. Please make an application. Please make 46. What is the demand notice, Mr. 88 lakhs. Yes, yes, madam. 46. Then issue notice so and so, etc. Right?
Oh, that's all. Notice is issued.
Issued.
Yes.
Right. So heard on IA number so and so. Sum of 88 lakhs is demanded, right? Learned counsel for the petitioner submits that he shall deposit 50% of the amount. You said 50%, right?
50%. There was labor cess.
What else? Then you have to give us this thing. Don't expect us to do all this. No. See, Mr. In that case, he has given us a chart running into 4 pages. What is the calculation? What amount has been stated? That's how we have arrived at the figure of 50 lakhs. It's not that just off the cuff we have said. He has given, please show.
In my case,
that Mr. Krishnamurthy's case, you should understand before that, before you speak. So you should understand before you speak. No, give that chart
Yes, in
which
that.
he gave.
Yes.
Please see. This sort of chart you will have to prepare. What is the amount due and how much will you pay? It's not like this.
Prepare a chart. You prepare a chart.
That the chart has been given to you to have a look at it, not to make or. Please make that chart. What has been stated? What is the amount deductible? Separate heads. He has worked it out. Not oral submission, passing on the buck to the court, right? Don't do it.
In my case, in demand, except serial number 7 and 8.
You prepare a chart, Mr. Counsel. You prepare a chart, the other and serve it on the other side. Now they are agreeable for that. Having looked into the chart, they are agreeable. Similarly, you also file a chart.
They are putting a particular date related to betterment charges.
All right. When this court required the counsel for petitioner to furnish a chart with regard to demands state, this is unfortunately this is the language which you understand. That's what my brother told twice. So no, if you don't have this, if you understand only that this language, we will say so. My brother told you twice, please. I told you once, but if we are good to you, you don't, get it. It's unfortunate. We are being good to you. We are telling you, please file. If you don't want to file the chart, we will dismiss it. Fine. Go to Delhi. Fine. What to do? First of all, this out of turn mention is being made. And we are entertaining this. And despite that, if you are not willing, have it. We will reject your prayer for interim leave. Yes, he has really worked hard to tell us. That's what we are telling you. It's not without any basis that we have quantified the figure of 50 lakhs. Please understand. If you can't do it, don't do. Can't do it, can't prepare a chart like this. We asked Mr. Srinidhi to give a chart to you. What else can we do? That you prepare a chart like this. What else can we do? Raise for adjournment 46 list next week.
Number 30.
The great difficulty has got the record. Why are you seeking adjournment? Next date, he will not have the record, right? It will be taken back. See. Why should you not argue, Mr.? What is it?
Tomorrow is.
Tomorrow? You will retain the record, right? When it's counsel for the petitioner prays for short adjournment. This tomorrow, whatever day. Tomorrow is 10th March.
Lord, I am for respondent number 2.
I remember here. Yes.
I am for respondent number 2, my lord.
Ready?
We are ready.
Ready? Oh, it's for our assistance, for our benefit. Yes. All right. Yes, yes.
consenting to what I was not served, or rather, even if I was served, there was no endorsement in the order field whether I was duly served, placed ex parte, nothing. Even before my written statement or anything was filed, the principal letter was not consented to what decree being passed. Your Lordship kindly take that was filed at page 59 annexure C. 1 and 2 submit that he is very much present before his honorable court and concedes to the payment of the amount of the plaintiff consider what the information of the also. Commencing from August 1994, honorable court will be pleased to pass decree accordingly after the order signed by defendant numbers 1 and 2. I was defendant number 3 in that thing.
Dependent 1 and 2 are the principal borrowers.
Yes, principal borrowers. But you see what happens. Page 60, the next page is the decree that is drawn up by the office. Right copy. We get 61. The suit was filed on 14/6/93 for a judgment and decree that the dependents shall place also. So the office made a ministerial mistake by drawing up the decree against all the defendants, including myself. Not from 1993, I am fighting this and saying, please proceed against the people you don't have consented to the decree, not against me. Therefore, Lord, when I filed an application before the trial court, at page 64, for modification of the decree under section 152 and 153 of the these modification applications, there was a state 69, page 69, it was state. And thereafter, Lord, this entire proceeding, because the DRT was constituted thereafter. So the entire proceeding was transferred to the DRT, including this application under 53. Now, DRT says, I am an executing court, I can't go behind the decree. You have to go back to civil court. Civil court has transferred the decree to not the DRT to consider everything. Now, your Lordship sees, from 1994 till today, no action is taken by the bank against the people who have consented to the decree. I am being hounded. Therefore, your Lordship, you kindly see, when stay was granted by this court, at the first instance, after hearing, please look at the order dated 24th of February 21. The interim order was granted after hearing. There was an order passed by your Lordships on the last day of the hearing. Very detailed order that is passed.
Yes, 10th August.
10th August. The council for the appellant has argued before this court, responded to bank has filed a civil suit. The principal debtor paid to file before this court as the against the present appellant was carried out, and he was never served at any point of time. It has been stated by the learned counsel that the principal borrower consented to the decree. Later on, when the present appellant came to know about the decree, he preferred an application for correction of the decree. However, when the application was submitted to the trial court,
Then interim order granted. We continue that and give liberty to the bank to proceed against the.
All right, yes.
However, when the proceedings were transferred to the executive tribunal or the court of distraction to the executive tribunal.
Yes.
Yes.
The learned counsel appearing for the appellant has argued before this court that the application preferred under section 152 was not decided by the DRT at any point of time, and an ex parte decree is being enforced against him. He has stated that the dispositions preferred by the appellant for the rights of the judge will be issued or account available. Stating that there is certainly a alternate remedy available. However, because of the fact that the appellant petitioner was not heard by the civil court or by the DRT, the application filed under 152 has never seen the light of day. It is further contended that the order passed to the DRT is against the principle.
Monday. Yes. Yes.
The fact that the applicant petition was not heard by the city court or by the DRT. The application filed under Article 2 has never seen the light of day. It is further contended that the order passed by the DRT is against the principle of natural justice and fairness. Therefore, the alternate remedy will not be a bar in the present case. The counsel for the applicant was able to make out a prima facie case. The remedy of proceedings only to the extent of the present applicant is concerned between state with the next state. The respondent bank shall be free to recover the amount of the other persons in the 94 fields today were not, they have not taken any action against the people subjected themselves. The logic of the rent under 132 of the Contract Act, or contract of guarantee process. Data.
Yes.
Consents to a decree being passed. There is a modification of the contract. Is that extension of it? And there is a new fresh contract that comes into existence between the principal debtors and the bank. And it gets substituted in place of the statement of objection filed by the bank. Last sentence of first page. Respondents 3 and 4. For defendants 1 and 2 is said to agree to pay the decreed amount, and as such the decree was passed against all the defendants in this. Yes. 1 and 2 consented, but how could it have been binding as far as I am concerned? I asked myself a question.
Yes.
Then please come to the end of page 2, third line, last line. While it is true that the respondents 3 and 4 filed a memo consenting for a decree to be passed, it is only submitted that respondent number 2 was not a party to the said memo. I was not a party to the said memo. And it was not a consent memo filed by the bank and the principal debtors. There was neither a contract between the bank and respondents 3 or 4 nor any act or omission of the bank releasing the borrowers, enabling discharge of surety as envisaged under 130. Paragraph 6, small amendments made in paragraph 6, 7, 8 are not included except the bank. Then the appellant filed an idea before the civil court for amending or modifying the decree, and the said application to transfer to the tribunal.
Yes.
Paragraph 12.
That's it. Let's hear what he has to say. Yes, Mr.
Wait, please, my lord.
Yes.
My first submission would be that we may go to the prayer in writ petition number 32965 or 2013 at page 41 of the writ appeal.
Yes.
Where the prayer is against the order of the Debt Recovery Tribunal. Issue a writ of certiorari or any other writ, order or direction thereby quashing and or setting aside the impugned order dated 17/6/2013 passed by the Debts Recovery Tribunal Karnataka and OA number 719/1997. So my submission is that it is an writ petition has been filed against the order of the DRT under section 20 of the DRT Act. There is an alternative efficacious remedy to go to the DRAT under appeal, my lord. Instead of it, they have come directly to this honorable court. That is my first submission. Section 20 of the DRT Act clearly says that any order passed by the DRT, there is already another avenue to go in appeal before the DRAT. And the learned single judge also has taken the same view And on that ground only, the writ petition was not allowed. Secondly, my learned friend is telling that there was a consent decree. My submission is that in the civil court, when the defendants, there was no consent decree. That's what my submission is that. Because he is trying to rope in section 135 of the Contract Act, but there was no composition or consent by the bank, because they themselves directly came to the court and they said, we are willing to pay the amount, give us some installment. And the Honorable Court has granted some installment to them, and then the decree has been passed. I am not a party to it at all. So where is the question of a consent decree? And then there was no consent by the bank for this kind of decree, and it was directly passed by the Honorable Civil Court. So I am not bound by it at any cost. And then when there is no consent, the question of 135 of the Contract Act coming into force would not arise at all. That is my second submission, my lord. Thirdly, at the time when section 152 and 153 applications were filed before the City Civil Court, it was in 1999. In 94 itself, the decree was transferred to the DRT. For 5 years, nothing was done by the learned writ appellant. And then, when it came before the DRT, DRT issued the summons to appear, including him. He did not appear. Then he filed a miscellaneous appeal, and then it was set aside, ex parte order, and he was allowed to file an objection. He filed this objection before the DRT, and then the bank filed its affidavit of evidence. He was allowed to file his defendant's evidence, and then finally, considering all the matters, the Honorable DRT passed a considered order, telling that he is also liable, because in his objection, he had not taken a stand that he was not a surety, nor he was not liable. I would like to take your honor's notice to...
Sir, Mr. Counsel.
Yes, sir. Yes,
you made a statement that you are not party to the consent.
Yes, yes, my lord.
Half court fee is refunded to you?
No, I have to check up, my lord.
No, that is the order?
No, that may be the half court fee is recorded, but we have not consented at all, because without any contest, it has been passed.
Then how you are entitled for refund?
I would like to take your honor to that particular order, my lord.
Memo files states so, and the court has directed refund. Page
My
61.
objection is order sheet annexure B, order sheet in OS. Annexure B at page 57. At page 57, annexure B, my lord. Where at page 56 itself, my lord, on 21/8/1993, plaintiff by Sri PV, order sheet says, defendant by Sri D1 and D2, Tajuddin. D3 served on office. It was served on office. He kept himself away, did not appear all through the entire proceedings.
You are right, but you made a statement that it was not a consent by the bank.
Yes, there was no consent. That
not correct. The memo itself says that half court fee has to be refunded to you, and the court, considering that memo, half court fee is refunded to you.
No, that
unless there is a consent decree, where is the question of refund?
No, honorable court may look into the order itself. The 57, my lord, 2011/1993, ex parte evidence by 4/12/2013. Then again ex parte evidence by 4/1/94. Then again ex parte evidence by 21/1/94. Then
all those things are not in dispute.
Yes, 58, my lord.
Only clarification I sought that whether
my honorable submission that alone will not be going to prove that it was a consent decree. It was might have done by the concerned advocate and who has simply filed an application and got it. But that does not mean that there was a consent. My submission at page 58 of the order sheet, Your Honor, defendant present, concede suit claim, memo filed, rupees 60,000 suit decreed as prayed for, pre-decree heard. The defendant shall pay the suit claim at the rate of rupees 25,000 per month. That is what they have said. Refund half of court fee to the plaintiff. We are not a party. We had not even asked for it. Page number 58, my lord. 29/1/1994 order passed by the Honorable Civil Judge.
Page
58 order sheet, annexure B, my lord. Page 58, annexure B to the writ appeal.
Yes.
Their own document. There is a defendant present, concede suit claim. Defendant concede suit claim, not the plaintiff. Memo filed. It was heard. Then they passed an order. Nowhere it is mentioned that we were present and we were a party to it. Refund half of court fee to the plaintiff. Court on its own has passed that order.
No, so did you file an appeal? Were you agreed by this decree?
Yes, my lord.
The decree was in your favor, right?
No, decree was in my favor. I don't object because entire decree was passed in our favor. We had no question about it. Question was whether it was a consent decree or not, because 135 clearly says that there must be a consent by both the parties. There was no consent at all. So where is the question of discharge? That is my argument, my lord. Thirdly, DRT has given all opportunities. Under the section 22 of the DRT Act, they can go by principle of natural justice. And again, section 31, Your Honor, 31 of the DRT Act, where I would like to read that where any suit or other proceeding stands transferred from any court to a tribunal under subsection 1, the court shall, B is relevant there, my lord. The tribunal may, on receipt of such records, proceed to deal with such suit or other proceeding so far as may be in the same manner as in the case of an application made under section 19 of the DRT Act from the stage which was reached before such transfer or from any earlier stage. The DRT has had full powers. So they actually went behind also.
All right, we will hear you. Appeal is admitted for hearing. Interim order shall continue.
Posted?
Posted for hearing.
Posted for hearing.
Okay.
Thank you.
Not commencing, this is admission, a preliminary hearing. What is preliminary hearing? Is it so? Then we have to await, right? 30 in your which madam 32.2 when 11/2 in view of order dated 11/2/2020 hearing of the appeal is deferred. This is 32.2, right, madam? Nothing is happening. Nothing is happening. We are deferring. Your application will remain pending, right? Yes, madam. What do you say? Not an infringement. Third on IA. Which is your IA? 1 of 2021. Third, learned counsel for the parties, learned counsel for the applicant submitted that she has no objection to prayer for impeachment in view of officer submission and for the reasons assigned in IA 1 of 21, same is allowed. Let amended cost I think be filed within 1 week. And then in view of order dated 11/2/2020, hearing is deferred. Yes.
Number 33, the DP party, government advocate.
With your lordship's kind leave, my lords, I appear for the appellant. My lords, a similarly placed issue, the issue involved in these appeals is.
IA 1 of 21 is dismissed as not placed. What is it?
My lords, the same issue is pending in serial number 58, which is listed today, my lords, for final hearing. This is, my lords, prescription of a time frame for passing of final notification under the KID Act. Now, my lords, in the present case at hand, the said acquisition was set at naught, my lords, because even despite the lapse of 5 years, the final notification was not issued as such. Now, my lords, whether the statute does not per se provide for a time frame, my lords, like it is there in the Land Acquisition Act. So
it has to be done within reasonable time, nonetheless.
Nevertheless, my lords, the same issue is being considered for final hearing in a connected petition at serial number 58 today, my lords.
At least along with 58. What who will lead? This thing, notice has to be issued, right? Issue notice to respondent number 1 and 2 accepted on behalf of learned additional. No, issue notice. Notice is accepted on behalf of respondent number 2 by Mrs. Vani. Learned additional government advocate, office is director to reflect her name. Issue notice to respondent number 2. 1 list immediately after respondent number 1 is served. We will not link it with 58 because the question has to be decided in facts of each case.
Please, be clear.
Number 34, Mariappa.
I beg to paper appellate, my lord. My lord, in this writ appeal, my lord, previously, annexure came, my lord, page number 38, my lord. Previously, the Honorable Court was pleased to pass an order of the writ of mandamus. That page number 40, my lord, your lordship judgment, my lord. Thereafter, my lord, as the authorities have not considered, once again we give the representation by giving the judgment of this Honorable Court dated 3/4/2019 in writ petition number 48337 of 2018. That is annexure K, my lord. As the authorities have not considered, that's why, my lord, the petitioners have filed another writ petition before the Honorable High Court.
You can't do like this.
And my lord, that order is
was not passed. You should have filed contempt. Earlier order was not passed. You should have filed contempt, right?
That's why I sought the permission on that time, my lord, before the learned single judge. But learned single judge rejected my prayer and put the cost on me, my lord, of rupees 15,000. We are running the
or wrong legal advice tendered to the client, presumably. Yes. So what is?
That's why, my lord.
So how was second petition? Lord, did you disclose in your writ petition?
Yes.
I disclosed, my lord. I disclosed before the learned judge narrated that previously the Honorable Court, that is your lordship judgment, my lord. That is annexure K, my lord.
You should withdraw this writ petition. We will permit you to withdraw this writ petition.
Yes, ma'am. Yes, ma'am. The cost may be.
Right. This intra-court appeal has been filed against order dated 4th of June 2021, passed by learned single judge, by which writ petition preferred by the appellant has been dismissed on the ground that a similar writ petition was filed by the appellant on namely WT number 48337/2018, which was disposed of by an order dated 3/4/2019. Paragraph. At the outset, learned counsel for the appellant clearly submits that the second writ petition seeking the same relief was not maintainable. However, it is pointed out that the petitioner had disclosed the factum of filing the second writ petition in the first writ petition in the subsequent writ petition. Full stop. He therefore seeks leave of this court to withdraw the writ petition. Paragraph in peculiar paragraph in the fact situation of the case, and in view of the case that the appellant had disclosed the factum of filing of the first writ petition, we permit the petitioner to withdraw WP number 12562 bar 2020 in the 2020. Accordingly, the order passed by the learned single judge is modified. Is set aside in the result of the.
My lord, with liberty to file contempt, my lord. My lord, on submission, my lord.
Filing contempt, why you want liberty, mister?
Because of the limitation, my lord. That's why limitation, because, my lord.
No limitation under Article 215. It's inherent power.
Much obliged, my lord. Much obliged.
Much obliged means what? Ask the court anything, right? And the court answers, then say obliged. I wish I could have practiced like this. Yes.
35.
Yes. What non-furnishing and what APTC notice? Employment notification was issued by whom? All right. Then
Lord, if a candidate is applying, taking benefit of reservation, page 61, number 10, paragraph number 10. 4. See, he had to obtain a form F and produce form F to show that he belongs to 2A category. But they applied under 2A categories, the application is at page 66. It's from top. Page 66. Where his examination he was shortlisted, and his name was found in the preliminary list of candidates. On verification, at the time of verification of a document, he has to produce documents. He filed Form F, which was only for the purpose of the education issued by at page 111. Now, after Form F, says for educational purpose would be based on this, an endorsement to issue at page 103, indicating that the certificate is only for educational purpose, it cannot be used for employment, because the notification, the endorsement itself, the form itself states so. Page 103 the translation. Before we issue the impedition, the notification. The learning is not because it says education, you cannot reject it, you have to consider it. At page 24, page 24, right, resolving of the impedition, not only this endorsement was fought, the entire notification was fought under which the recruitment process has gone on and not recruited. During the pendency of the impedition, this honorable court directed that he should produce a certificate if he has it. If on a memo is filed on 22nd of February, he produces two notifications, two forms. One is dated 9/9/2014 and another one dated 3/2/2018. Therefore, not we had a form of 2014. The one produced before us was of 2015. We did not produce it. So therefore, a submission was made. We will consider this in the normal course not and take a decision. Because this has to go for verification in the normal course, not along with other credentials.
This court on 21/2/22 already has modified the order of single judge. Yes, it is modified. Therefore, that grievance should not be there.
Which is the order?
21/2/22. Yes, yes.
Yes, fine. All right. Yes.
Original
which is the for this form? Which is the form of dated? Form F is dated 9/9/14. Fine. This intra-court mark the presence, Mr. S. Sriranga, there is senior counsel with.
Original, you keep it with you.
Hey, why are you giving? We are not going to verify this for you. To say that he will do it. He will do it. It will not change. You are appearing for which respondent? Respondent number 1. But this intra-court appeal has been filed against order dated 13th of July 2021, passed by Learned Single Judge in WP number 22945, part 2019. Full stop. When we have heard Learned Counsel for the parties at length. Learned Counsel for the respondent number 1 fairly stated that he had challenged the notification dated 25/5/2019 insofar as it pertained to respondent number 1. The who said 1?
You are
insofar as it pertains to respondent number 1 and 2. This 25/5/2019 has challenged only in respect of respondent number 2, right? After hearing Learned Counsel for the parties and taking into account the nature of controversy involved, the order dated so and so passed by the Learned Single Judge is modified, and it is directed that the notification dated that notification and the notification dated 25/5/2019 is quashed only to the all right, so order just a minute. The order passed by the Learned Single Judge is modified and it is directed that and the writ petition is disposed of with the following directions. Number 1, endorsement dated 8/4/2019. This all bearing number it's there 34 page is quashed. That's all. That's all. 8/4/2019. Second, the appellant number 1 shall consider the candidature of the respondent number 1 for the post of assistant engineer within bracket electrical under category 2A general and that's all within a period of 8 weeks from the date of receipt of copy of this order. How much time?
How many posts are there? How many posts are there? How many posts?
But we have not heard then the notice has been issued to respond.
Single judge has quashed.
Yes. Yes, Mr.
And then that order is already filed.
Wait, hold on. Wait, 135 document is-
That is R4 is R2.
It's already, all right. So then what have you written? Quest and number 2. Thereafter, right, number 8/4/2019 is quest. Secondly, notification dated 25/5/2019 insofar as it pertains only to respondent number 2 is concerned is hereby quest. Then consider within 8 weeks you have said make it 12 weeks.
Not 4 weeks, I will state the process of sending it for verification. But I have to receive it from the government department and university where these marks start for verification. After 2018, earlier you would give an employment subject to verification.
All right, so the appellant shall complete the process of scrutiny of documents at its level within a period of 4 weeks, and thereafter shall refer the same to and refer the documents submitted by respondent number 1 for verification to the state government. To the aforesaid extent, the order passed by learned committee modified accordingly. Appeal is with consent. 4 weeks. They will do it. Government is party. The state government is not a party. We can't sign. So 4 weeks they will forward it to the government. We have said 4 weeks. Time limit government is not.
And we expect the competent authorities to.
But the government is not a party. How can direction be issued? No, that you have not heard. That means you have not heard the orders. Who will verify the documents? That's what he's saying, that they have to refer it to the state government for verification. And the state government is not a party. We don't know. You consult an astrologer. Maybe he will tell you what will happen after 1 month, after this, and you talk. Ask him that the government they have sent the documents by employer to government when it. No. State government is not a party. Can we issue direction to a person not a party? Supposing if you are not a party in this proceeding, for a moment, would we have said like issuing a direction to you? What you would have told? Not possible. That's what he's saying. No, that at their level they will furnish whatever they will to do the complete the process within 4 weeks. We have said so. Thereafter, he cannot control the state government, right? You talk to this thing, madam. She will help you out. Huh? Yes. And this court is always open, right? 5 days a week, and at times 6 days a week also. Right? You can always come.
Number 36, Sri Prakash, government advocate.
What to do? 30 years. Oh, thank you. Thank you. We wish that we really appreciate and wish that majority of the members are there. 30 years.
You want to say something? Yes.
So, what? So, appeal has been filed by legal heirs, right? Fine. We don't, normally we would have remanded, but we do not remand because we have heard 30 days here delay. Fine, thank you. We'll pass an order. Thank you.
37. Here we are doing one day.
Yes, Mr. Padmanabh.
37.
No, you are before the courtroom, right? Huh? Keep
Mr.
your-
Padmanabh.
Padmanabh, sir. Here we are doing one day.
Huh? Yes. No. Last date also you did not appear, and please see the order. You are seeking the relief against respondent number 2. What is respondent number 2? Huh?
Private hospital.
Private hospital. So then a writ petition can be maintained. That's the reasoning assigned by learned single judge, that it is not a state under Article 12, therefore writ petition is not maintainable. You can't make it maintainable by keeping this petition pending unless you have come to know about the plans of the state government to acquire the hospital and to declare it as a government hospital. There's no point. You have done your job, right? You don't know anything about the case. You are not the counsel, and somebody has made a request to you. That's why you are here. Fine. Huh?
The appellant is come up before this court, the husband of the petitioner died due to COVID. Thereafter, the second husband refused to give a treatment, on the hand of God. I have no alternative.
Whether a writ can be issued as against a private party.
How is it? The respondent number 2 is amenable to writ jurisdiction of this court, Article 12. That's what you have to tell us. What happened is the story. Yes. No, nothing. See, Mr. We are not sitting here to repeatedly adjourn the case and to read the same files over and over again. No point. The situation will not change unless by tomorrow, if you say it will become a government hospital and will be within Article 12, we will adjourn it tomorrow. Nothing can be done. Advise your client to avail of proper remedy. You are there, advise. We have adjourned it once. Okay. Please tell us how. This writ petition. In this writ petition, the petitioner inter alia has prayed for the following reliefs. Right. We have heard learned counsel for the petitioner. Appellant. No, the learned single judge. Learned single judge dismissed the writ petition by an order dated 16th of August 2021 and has held as under court page 10, 3 lines. Petition is accordingly dismissed. Learned counsel for the appellant was unable to point out as to how respondent number 2 is unable to writ jurisdiction of this court. Full stop. For the aforementioned, we are in agreement with the full stop. Respondent number 2 is not a state within the meaning of Article 12 of the Constitution of India. Therefore, no writ petition is maintainable. However, the appellant is at liberty to take recourse to such remedy as may be available to her in law. With the aforesaid liberty, the appeal is dismissed.
38. GK Bhatt. Subsequently, it was converted into a partnership. With all these things with the knowledge and permission of the respondent, relative government partnership. 1 to 4. Thereafter, my lord, the partnership was also involved. And the respective partners surrendered their right and it was made individually. The petitioner by name. How I do? Is that great name as the time was. One of the relative activities, the entire day was for the most of April time. Meanwhile, what is the event? The respondent bank, when Karnataka state registered of this the plant and machinery corporation. The plant and machinery was purchased by the general respondent. The applicant continued erecting the model and the plant and machinery. At that time, my lord, the respondent corporation issued a notice of disposal. Again, my lord, there was a expectation in the direction of consider various implementations are made. To complete that, because the entire consideration amount after the cost of pay, apart from the rent, the cost of the cost of pay is from their agreement for 20 years. After 20 years, the regular saving has to be executed by 10 years of the AIA decided. They did not manage the direction of thereafter, A and B were and handover the position to the seventh respondent who is only a purchaser of the plant and machinery, not the plot. The plot has never been sold. Corporation has resources allotting by due process. One of the things that is not built to consider an important aspect of the matter and to whether if you want to take on the plant and machinery, the amounts to disposal. The disposition is not. I have adapted the new plant and machinery. When it actually the industrial activity continues by the applicant. So on this matter, don't matter. By you from getting your software that has not been done. So without having resources for us, I mean, it's only the plant and economic fraud. So I am addressed by
What?
Selling of the plant and machinery, the amount of disposal.
They will have to take possession in accordance with. We don't know what they will do. Yes. No, we have heard you on admission. We consider what else? Yes. Fine. So what? What?
directing the respondent to the plaintiff. This will arise only if annexure A is passed. If additional prayer is one of the same, B and the additional prayer is one of the same.
That's fine. So what? Hey, tell us 2 grounds why it should not be entertained. We have not heard him in detail. He has been brief to the point. You are arguing, then we will admit it if you are interested in arguing the case. Why it should not be? We have heard him only on preliminary hearing. He has said he has raised 2 contentions. That sale doesn't amount to termination of lease, and by sale itself, he won't be dispossessed. He can't be. He has to be dispossessed except in accordance with law. These are the 2 grounds raised. If you want to argue it de novo from reading from petition and prayer, then we may as well hear the case. All right, thank you. That's all. Give it. Where is it? Affidavit. All right. Yes. Okay. Yes. Yes. Thank you. Yes.
Then on one side, it was a lease mirror, but 2 plus 18 years is not a sale. It's a lease. Then who the lady?
We will go through this table. Yes.
Yes.
All right.
Here, this case is say he is a part. In another way, he is a proprietor. If he is a partner, section 69, if he is a proprietor at no contract, there is any lease. There is no contract.
That's what it has been held. Thank you. Today itself, nothing reserved. Before 1:30, order will be passed. We are waiting for you to go out. Normally, we don't pass an order in the presence of the counsel because he will have a tendency to interrupt, right? If we say something, he will interrupt. That's why. Nothing to reserve. Nothing to reserve. Yes, you know it. But I always thought that I have stayed here long enough so that the bar knows me. Okay, thank you. Huh? Yes. Huh? Yes, Lord. Thank you. Yes. Yes. 39. Yes, please.
39. The Malipati case, the Mohammed Karim, Bhati Ashok.
Is there a conflict between Karnataka
Hey, Mister, you are such a. He has understood what order will be passed. You give it back. It has not been supplied. He has left the courtroom. What is this? No, we will admit if you are so anxious. So anxious to argue, then we will admit it. He has understood what order we are going to pass. He is a senior counsel. We did not want to pass an order dismissing the appeal on his face. So therefore, we have asked him to go out. Despite that, I'm passing on and all that. So if you are anxious to argue, want to seek instruction, we will admit it. Yes, please.
General act of Karnataka Public Premises Law, the unauthorized occupant can be evicted by the competent officer after giving notice and hearing him. In the work board, the competent officer is the CEO who issues notice and pass. in 1999, the Karnataka Act was also amended to include the definition of public premises, the work properties which are registered with the work code. Admittedly, all these properties are registered with the work code, not with the work act. Under the work act 2013, there is an amendment. And here to that, we have they introduced provisions of Actually, 85 said bar civil court to execute. There are judgments to say whatever is covered under 83 as to the questions which can be decided by the work tribunal. The civil court is but here we are in 2013, they amended and also said in the work act the provision to say eviction of tenants also is mentioned there. In view of that, we are as against the orders of the competent officer. If petitions were filed to pay, you cannot invoke the under the work act with the work tribunal or the contentions raised. Before the learned single judge, the work code raised a plea that the Karnataka Act is a special enactment, whereas the work act is a general enactment. The observation that the finding was given may not way back from Karnataka High Court, matter of the Honorable Supreme Court, which I separately given. And the Honorable Supreme Court says work act is a general act, the big government act is special. There with that we are going to do. Now we have the learned judge has discarded my contention or rejected my contention on this issue that it is a special enactment. There is also a provision for eviction of occupant. And in the work also there are right.
Yes.
Now we are since the work act is being and public premises is doing a special enactment. This act will prevail and orders made thereof. There is an appeal provided to the government district judge and thereafter it becomes final and there is jurisdiction to prevail jurisdiction to take. Therefore, my lord, the orders made by the competent office, appeal my lord again have an impact to the government is still maintainable, notwithstanding the fact that the work practice amended. That is the main position before my is only one judgment. But in the district authorities, has given before the court on 15th of November.
Right. Notices have already been issued. What is to it is to be heard finally?
Represent.
Who appears for this thing? Who is contesting this appeal? R1. Which appeal is admitted for hearing? List on 31st March. List on 31st March 2022 for hearing. Yeah. What is the interim order? We consider finally decide on the next day, 31st. Yes.
Giving 3,000 such cases. So that was my humble request.
Definitely. Yes. Good. Yes. DK Bhatt, right? Yes. Senior counsel for the appellant. Mr. P.R. Ramesh, learned counsel for respondent therefore. This the court appeal has been filed against order dated 1st of October 2021 passed by the learned single judge by which read petition preferred by the appellant has been dismissed. Paragraph. Facts giving rise to filing of this appeal. Quickly stated that a plot of land, that an allotment of a plot of land was made in favor of one Shri Prabhakaran Pillai on 3/6/1977. Full stop. On 1/7/1977, the plot was leased for a period of 2 + 18 years. 2 + 18 years. Full stop. After his death, the plot was transferred in the name of his legal representative, namely his son, Shri P. Prabhakaran Pillai. Full stop. This was made by Shankaran Panikar. Respondent number 4 permitted the transfer of the plot in question on 29/81. The transferee sought permission of change of constitution from proprietorship to partnership by inducting other persons as partners. Thereupon, respondent number 4 accorded permission for change of constitution subject to after the corporation on 9/3/1983, right? Corporation 9/3/83 granted permission for change of constitution of the proprietorship firm to partnership firm. Full stop. Deed contained the names of partners in the partnership. In the partnership, 8 persons were inducted as partners. Full stop. And thereafter, granted approval specifying the shareholding as already shareholding after the approved that after death of Mr. Panikar, his 51% share would devolve on his legal representative in accordance with the personal law applicable to them. Despite notices, the appellant did not get the partnership firm registered. Full stop. Full stop. The corporation sent notices on 17/5/2006 and 19/7/2007. However, despite despite opposite notices, the appellant failed to furnish the documents such as permanent SSI registration certificate, renewed insurance policy, audit balance sheet, VAT returns, NOC from Karnataka Industrial Cooperative Bank, certificate from SSI Association, about functioning of the industrial unit, full stop. Thereupon, the corporation decided to sell to auction the plant and machinery, full stop. The auction the plant and machinery, plant and machinery, the aforesaid full stop, the aforesaid plant and machinery was sold, no? Auctioned, full stop. The aforesaid action was under challenge in a petition, full stop, the learned single judge by an order dated 1st of October 2021 has dismissed the petition. Paragraph. Learned counsel for the appellant submitted that learned counsel for the appellant submitted that the sale of plant and machinery does not amount to termination of the lease, and the selling of plant and machinery and sale of plant and machinery does not amount to disposition of the petitioner. On the other hand, learned counsel for respondent has supported, respondent number 4 has supported the order passed by the learned single judge. Full stop. Paragraph. We have considered the submissions made by learned counsel for the parties and have perused the record. Full stop. The petitioner has failed to, appellant has failed to furnish the necessary documents despite notices issued by the corporation, and has also failed to get the partnership registered. Full stop. Therefore, the corporation is justified in cancelling the allotment for violation of the terms and conditions of allotment. The appellant has not produced any material before the learned single judge that the partnership firm was converted into a proprietary firm. Has not produced any material to show the conversion, so and so. Full stop. Therefore, the learned single judge has rightly. Therefore, the learned single judge has rightly declined to entertain the writ petition. Full stop. We do not find any ground to interfere with the order passed by the learned single judge. Then say, not find any ground to interfere, right? In the then learned single judge is writing this sentence will come thereafter. In the result, appeal fails and is hereby dismissed.
Party,
Yes.
My lord, I'm appearing on behalf of Senior Counsel Subara for the respondents. Senior is extremely unwell and is unable to appear, my lord. May I request a short adjournment?
Mr. What's your name? Learned counsel for the appellant. What's your name, madam?
Shilpa, my lord.
Shilpa Prasad, learned counsel for respondent, submits that the arguing counsel, Mr. Subbarao, is unwell. She therefore prays for adjournment list after 2 weeks.
Grateful, my lord.
2 weeks.
Party 1, Sri Padmanabha, government advocate.
The counsel. Asking what he was doing. Huh?
Mr. Counsel, Mr. Padmanabh, you have muted yourself.
Appointment on compassionate grace. When? That's good. Yes. Fine. So we'll dispose of with the liberty to the petitioner to assail that order. Yes, this intra-court appeal has been filed against order dated 20th July 2021, passed by the learned single judge by which a writ petition prepared by the applicant has been disposed of with the direction to the competent authority to consider the case of the petitioner for appointment on compassionate ground in accordance with law within a period of 4 weeks from the date of 4 months, paragraph. When the matter was taken up today, learned additional government advocate at the outset pointed out that in compliance of the order passed by the learned single judge dated 20th July 2021, the representation submitted by the appellant has been rejected by an order dated 21/9/2021. Full stop. Learned additional government advocate has placed the copy of the aforesaid order on record. Full stop. Paragraph. In view of aforesaid subsequent development which has taken place, the appeal is disposed of with the liberty to the appellant to challenge the order dated 21/9/2021 in an appropriate forum in accordance with law.
My lord, I am here. My lord, I am appearing. My lord, I am appearing. My lord, I am appearing for the appellant, my lord. My lord, I am appearing for the appellant.
Yes.
My lord, I may kindly be permitted to argue the case, my lord, on merits, because the order passed by the runner single judge, my lord, is not in accordance with the compassionate appointment rules, my lord. Now, your lordship, my kindly.
Sir Padmanabh.
Yes, my
Sir
lord.
Padmanabh.
Yes, my lord.
Now the government advocate has brought to the notice of this court that in subsequent to the orders passed by the single judge, they have already rejected your application.
No. The very order of the runner single judge, my lord, I am challenging here because the order passed by the runner single judge is contrary to the compassionate appointment rules. My submission. The learner single judge, my lord, has applied the rule 8.3, which has no application to this case.
No, that's all right.
No. My respectful submission, my lord, the rule 8.3 is not applicable. My lord, my request, my lord, to consider our case, my lord, in terms of appointment rules. That's all my prayer. In terms of the appointment, compassionate appointment rules, my lord, that our case has to be considered, not in any other rules. My lord, that is my respectful submission. Our case has not been considered, my lord, in terms of the appointment rules. That is the rule which is applicable. That has not made applicable to our case. The other rule has no application at all. That is the reason why, my lord, I have challenged this order. My lord, now the order, my lord, the order of the non-single they have implemented, but very order, my lord, I am challenging here. The very order of the non-single judge, my lord, I am challenging on the ground. It is erroneous on the face of the record, my lord. Your lordship may kindly see the compassionate appointment. Even, my lord, this order of the non-single judge runs contrary to the order passed by the division bench. Your lordship annexed D, F. Your lordship may kindly see. Annexed F also see, my lord.
Yes.
My only request, my lord, my case has to be considered, my lord, strictly in terms of the compassionate appointment rules 1993. No other rules is applicable to my case. They have rejected our claim, my lord. They have rejected erroneously our claim, applying the rule 8.3 of 2002 rules, which has no application at all. Now, your lordship may kindly say I have extracted the rules. Your lordship may kindly see page 7 in my appeal.
You don't want to challenge the order.
Mr. Padmanabh.
Yes, sir.
The grounds urged in this appeal will be kept open for you to urge it in the writ petition.
I just that may be made clear in the order. That may be made clear in the order.
21st September order.
We will say that.
Yes. Then so dispose of liberty to assail the order dated 21st September 2021. It is contentions raised in this appeal are kept open to be agitated in the writ petition in the subsequent proceedings, which may be initiated by the petitioner with the aforesaid liberty. The appeal is disposed.
Grateful.
Thank you.
Number 32, Sri Kiran Kumar DK, Government Advocate.
Heard on IA 121, an application for condonation delay taking after hearing learned counsel for the parties and for the reasons assigned in IA 1 of 21, delay of 10 days in filing the appeal is condoned. In the result, IA is allowed, let the appeal be listed for orders on admission on 16th March.
43, the Sampathi, government advocate.
Ah. Oh, you have made that. This is a right. No, nothing you argue. What is this? This is 33127. This is against an order. Every case is different. It's not Arkavati, right? It's Arkavati undoubtedly, but the learned single judge referred to facts of each case individually, right? So this writ appeal arises in respect of a order passed in WP number 33127 or 2015, right? Which petition it arises? So which same means number? There are 3127, right? No, 33127. So why did you say no? We said the same. Do I find this writ appeal against an order passed by the learned single judge insofar as it pertains to 33127? Of course. You are not filing. You are not parties in all the writ petitions, right? Are you? No, yesterday we told you something. Despite that, you had not taken the trouble to read it and come ready. You are ready, no? Good. Tell us at least what is it about? Against which order passed in which writ petition this writ appeal has been preferred? Tell us. 33127. So page 7. Page 7, come to page 7. Unfortunate that we are required to tell you against which order you have preferred an appeal. We can't expect you to argue, but we have to tell you against which order you have preferred an appeal. You are repeatedly saying no. Page 7. Read it from the beginning in the High Court of Karnataka. Read. So then why are you saying no? When we are saying that this is against an order passed in writ petition 33127, why are you saying no? So there is no question of understanding. This says right. Now you should be clear about what has been done. Your petition. Yep. No adjournment tomorrow. Undertaking. Good, good. Yes, you remember the undertaking. What's your name? Learned counsel undertakes to argue the appeal positively tomorrow. We don't know. If you are senior. So senior will argue. Right? Who is your senior? No, but when will you become? We are interested in seeing you as senior. When will you become senior? You will become senior only by arguing cases, right? Not seeking an undertaking, not seeking an adjournment, neither by seeking an adjournment nor by furnishing undertaking to the courts. Fine. So you should become a senior counsel, right? And you will become senior only when you argue. Good. Yes, tomorrow. So undertaking is there. Tomorrow no adjournment in the first round. You have to be here. Fine. Less tomorrow. Undertakes to argue and not to seek any adjournment. Less tomorrow. It's 10th March.
Yes, yes.
Why are you so afraid, Mr. to argue? We are sure that you will not have anything. You will be all right. After you argue, you will feel better. Law firm, right? Even I think formally there. Law firm. Quite sure. Yes. Oh, yes. Oh, good. Yes. 21 years delay.
Land question of granted to the appellate's grandfather, FIR.
Yes.
The applicants before the UCR, the appellant and her father is noted. They filed the application in 2006, 2007. It is year 1985. There is no other.
You did not know.
My grandfather was in the village. I had noticed the appellant's father. Father died. He was not aware of the transaction. Selling the property to my friends, clients. The experience after my father's death, when I went back to the village, it was then I learned about this. That is the explanation that I have given. Document to show that till then I was a permanent in the state of Bangalore. Because made the impression my grandfather was.
Yes.
Day after, the appellant's father went back to the village after his father's death. Right there, the application. The explanation that I have given in my
That's all.
The next claim state is after I instituted the proceedings.
All right, we consider. Next, we consider. Anything else? That's all. Thank you. Yes. 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 Yes.
But 45, came along
This is Maintainability of the writ appeal. What is it? AKR.
Maintainability is kept open on the last date. Open the issue of maintainability. They have said we will issue notice. Maintainability is already kept open.
Notice.
Yes. No, this is not.
We will issue notice keeping the issue of maintainability open. Keeping the issue of maintainability of this appeal open, comma, issue notice to respondents. It is
in the file.
In the file. Why with us? With where? Huh? File only. Yes. I don't know why we asked him to be cautious, because very often the synopsis etc. is misplaced. So he is asking whether in the file. So we are telling him only in the file, obviously. Why anywhere else? Yes.
Admission. 47.
Huh? Not feeling well. Give the file. Oh,
Here for the appellant.
Appellant, right? Huh? Appeal is admitted for hearing. Record. Directed to secure the record of the family court.
The 48, the 13 days, the
Early hearing, what was right?
Only with regard to interest. Only with regard to the interest.
Interest at the rate of 18%.
because we are saving actually 95% that was written.
You have filed. This early hearing, you have filed.
I do. Yes, right.
It says early hearing, early hearing by advocate for the appellant. That's why we are, you have filed. It says so. Word on IA 21 an application for early hearing allowed. So find a synopsis. All this, what happened when you deposited the amount, so that we save time. Otherwise, we would have to write everything and then. When? Not next week, not possible. 24th March. 24th March. That's it. Learned counsel for the parties. Before that, learned counsel for the parties undertake to prepare a synopsis and produce the same on or before next date hearing. List for hearing on 24th March. Interim order, if any, shall continue.
The Sanjay Nair, government advocate, Sri K. Krishna.
State counsel for the appellant prays for adjournment list after 1 week. 4 and 5. Office is directed to reflect the name of list as counsel for respondent 4 and 5. Office of the right. This up. Press, then say press for adjournment list after 1.
Number 50.
Lord, I appear for the appellant.
I'm told the second set of papers have been made part of your lordship's record. That was the reason why your lordship's adjourned.
Interim order is limited.
Beg your lordship, pardon?
47. What is this item 50 is being called and you are mentioning about 47? What is it? 47 interim order, if any, shall continue. I don't know whether
Item 50 is what your lordships have taken up.
50. In between, somebody interrupted.
Oh, I'm sorry.
50.
Within Prasad,
50.
Serial number 50.
Yes, my lord, I appear for the appellant. I'm told the second set of papers have been made part of your lordship's file. That was the reason why it was adjourned today.
What is it? Oh, acha, that matters.
SEBI, my lord, the security.
So where is Mr. Naganan?
My lords, I appear for the respondents. Mr. Naganan will join, my lords.
All right, you are there. Fine. Yes.
I'm here, my lords.
Yes. Okay. Yes, Mr.
Before I continue, I stopped at page 94 of the brief submissions yesterday. Would your lordship kindly take a brief look at the provisions of the Act before I continue? Now, kindly take the Securities and Exchange Board of India Act.
One minute.
But please go to the preamble. An act to provide for the establishment of a board to protect the interests of investors in securities and to promote the development of and to regulate the securities market and for matters connected therewith or incidental thereto. But this is the object of the Act. Now, these regulations that I was referring to yesterday, they're made under section 48. Section 48 of the Act. But 48, your lordship will notice, give me 48. Section 48. Now kindly look at 48 of the Act. Power to make regulations. Well, that will be section 30 at section 30. Power to make regulations. This is, as your lordships will appreciate, delegated legislation. The board may, by notification, make regulations consistent with the Act and the rules made thereunder to carry out the purposes of the Act. Now, please come to D, clause D, the condition subject to which certificate of registration is to be issued, the amount of fee to be paid for certificate of registration, and the manner of suspension or cancellation of certificate of registration under section 12. So this is one of the purposes for which a regulation can be made. Then DA, the terms determined by the board for settlement of proceedings, your lordships have already seen the settlement proceedings, under subsection 2 and the procedure for conducting of settlement proceedings under subsection 3 of section 15B. Then, my lord, DB, any other matter which is required to be or may be specified by regulations or in respect of which provision is to be made by regulations. Now, pursuant to this, the three relevant regulations have been made. One is the, your lordship noticed yesterday, the credit rating agencies at page 118. Now, what is relevant here is the definition of a credit rating agency. The petitioner is a credit rating agency. At page 118, Securities and Exchange Board of India, credit rating agencies regulations. But here, your lordship may notice two definitions. One is section 2, clause E at page 119. Clause E. Certificate means a certificate of registration granted by the board under these regulations.
Yes.
Then, my lord, kindly go to 120, clause. This is the petitioner is a credit rating agency. Credit rating agency means a body corporate which is engaged in or proposes to be engaged in the business of rating of securities that are listed or proposed to be listed on a stock exchange recognized by the board. But after your lordships have seen these definitions, my submission is this. There are three regulations. One is the credit rating agencies. The other is settlement regulations. The third is intermediaries regulations. Now, a brief submission at this stage is these regulations must be read together, keeping in mind the object of the act. They can't be read in isolation. Now, having made this preliminary submission, your lordship may now go to page 94, where I stopped yesterday. But definitions, regulation 22, B and C, it makes a distinction between designated authority and designated member. Now, kindly go to regulation 23. This is cancellation or suspension of registration and other actions. Here is a case where the settlement application is rejected. The petitioner says, my certificate is likely to be cancelled. That is why he is there before your lordships. Now, kindly look at regulation 23. Where any person who has been granted a certificate of registration under the Act or regulations made thereunder fails to comply with any conditions subject to which a certificate of registration has been granted to him, contravenes any of the provisions of the securities laws or directions, instructions or circulars issued thereunder. Now, on these grounds, a certificate of registration can be cancelled. At this, I'll just pause here. I brought your lordship's notice yesterday that the Reserve Bank of India and the board made an inspection of the books and papers of this credit rating agency and found several irregularities. That is why an inquiry was started. Now, holding of inquiry is regulation 25. (25)(1). The designated authority shall issue a notice to a person against whom an inquiry has been initiated to show cause as to why the action as contemplated against such person should not be recommended. So, my lord, this complies with the principles of natural justice. A notice is to be issued. Then kindly go to page 96, regulation 26. But this is very important. I request your lordship to note this. 26(1). After considering the material available and record and the reply, if any, the designated authority may, by way of a report, recommend the following measures. Not kindly see this. Now, it does not inevitably end with a cancellation. Please note the first clause. If the petitioner convinces the designated authority, then disposing of the proceedings without any adverse action. Then cancellation of certificate of registration. Then suspension of the certificate of registration for a specified period. Now, these three recommendations can be made by the designated authority. Now, kindly then go to page 97, 27(1). Here, it is the designated member. On receipt of the report containing the measures recommended by the designated authority, the designated member shall cause to forward a copy of the report submitted by the designated authority and call upon the noticee, again a show cause notice, to make its submissions in writing as to why the measures recommended by the designated authority or any other action as contemplated in these regulations should not be taken. Then we'll have sub clause 5. After considering the facts and circumstances of the case, material and record, and the written submission, if any, the designated member shall endeavor to pass an appropriate order within 120 days from the date of receipt of submissions under subregulations 2 or the date of personal hearing, whichever is later. We are yet to come to this stage. Before that, the entire proceedings, the power of the SEBI to proceed with the inquiry have been stayed. Appropriate order, again, I would request your lordship to appropriate order means an order which 26(1) clauses 1, 2, 3, 4 speak of. Now, from an appropriate order, would your lordship now kindly go to page regulation 33, which is at occurs at page 100. The person aggrieved by an order under these regulations may prefer an appeal to the Securities Appellate Tribunal against such order in accordance with the provisions of Section 15T of the Act and the rules prescribed in this regard. So my respectful submission is, eventually, if the authority, that is the designated member, comes to the conclusion that there are violations, that the petitioner does not deserve to continue in the business as a credit rating agency, and an order is passed to the detriment of the petitioner, a credit rating agency, so that the statute provides for an appeal. Kindly note that. Now, we are yet to come to this stage. Before that, they've invoked Your Lordship's jurisdiction under 226. Now, my lord, after having said this, would Your Lordship kindly take the order dated 30/7/2021, which rejects the petitioner's settlement application. That Your Lordship will find marked as Annex C in WA 1276 of 2021. WA 2026, my lord, I'm sorry I have not made that part of this compilation. But that is marked as Annexure C. This is the very date on which His Lordship Justice Narendra made an order staying all further proceedings. However, this order is dated 30th of July 2021. The petitioner also has challenged the correctness of this order. But please see the order.
Same order, that is the same document which is available in page 2 of these compilations.
No, my lord, that is Annexure C is not made a part of the compilation. I'm sorry.
In the compilation,
no,
order dated 30th July 2021.
Please, that is His Lordship Justice 30th July is it stays the rejection order. But then Your Lordship will go to the next order.
We have got this 64, 30th July 21.
Yes, my lord, His Lordship put me a question. This 30th July is stayed in WP 14590 by order dated 11/8/2021 at page 6 of the compilation. This order is stayed. Now, my lord, please see the reasons given. Reference may be given to the subject settlement application filed by Brickwork Ratings India Private Limited for settlement of inquiry proceedings initiated with a show cause notice so and so dated November 17, 2020. Since the subject settlement application relates to the default stated in Regulation 5.2 of the SEBI settlement proceedings regulations, the application was placed before the competent authority for consideration. Upon consideration of the application, the competent authority is of opinion that the same may not be considered for settlement since the default falls within the factors as provided in Regulation 5.2 of the settlement regulations. In view of the same, I am directed to inform that the captioned settlement application has been rejected in exercise of the powers conferred in Regulation 5.5. Now, 5.5, the constitutional validity of 5.5 is challenged. Now, well, at the risk of repetition, may I request Your Lordship to take a look at 5.2 and 5.5, because that is the reason which the authority, the board gives for rejection. Kindly go to the settlement application in my compilation. That is at page 14, settlement regulations. That at page 18 is the relevant regulation 5, regulation 5, 5.2. The board may not settle any specified proceedings if it is of the opinion that the alleged default, 1, has market-wide impact, caused losses to a large number of investors, or affected the integrity of the market. Now, in the opinion of the board, the settlement application is liable to be rejected for these reasons. Now, please see 5.5. Next page. This is the validity of the virus of this regulation is challenged in one of the writ petitions. Nothing contained in these regulations shall be construed to restrict the right of the panel of whole-time members to consider or reject any application in respect of any specified proceeding without examination by the internal committee or the high-powered advisory committee. Then regulation 8 also may kindly be looked at. Next page. The filing of an application for settlement of any specified proceedings shall not affect the continuation of the proceedings, save that the passing of the final order shall be kept in abeyance till the application is disposed of. But here is a case where the settlement application is rejected. However, no further action the board can take in view of the various interim orders I have already pointed out to your lordships. Now, I'm not keeping this in mind. If your lordships are pleased to take a look at my submissions, I will only draw your lordship's attention to the relevant submissions, which I have enclosed to this compilation at page 172. But in this paragraph 1, we make a reference to the pending writ petition. Then paragraph 2, rejection of the settlement application. Then paragraph 3, the reason why these matters are placed before your lordships. That's the notification dated 23/11/2021. Then, Lord, we have exerted the definition of a credit rating agency. Then, Lord, please come to paragraph 5. I'll read that. The object of the SEBI Act, which establishes the board, is to protect the interests of investors in securities and to promote the development of and to regulate the securities market. The interests of investors are of paramount importance. The Reserve Bank of India and the Securities Exchange Board of India inspected the records of the petitioner company, which discloses violations of statutory requirements detrimental to the investors' interests. Therefore, the SEBI commenced proceedings against the writ petitioners under the relevant provisions of the Act and the SEBI intermediaries regulations. Show cause notices were issued. Then the respondent made an application under settlement regulations for settling the lapses on its part. As stated above, the same was rejected on 37/21. Then again, my lord, we say that is a subject matter of another writ petition. Then the second rejection order is also challenged in writ petition 14590. Then we say, my lord, that we have made applications for vacating stay at paragraph 10. Then at paragraph 11, my lord, we give the dates, the various dates on which these applications for stay were listed, and eventually on 18/11/2021, your lordship saw that order that there are important matters, more important matters. I have no time to consider these applications. Of course, my lord, it was urgent at the end of December, but by then the 23/11 notification came into force and it was placed before your lordships. So, my lord, paragraph 13 is important in my respective submission. The submission is that the interim orders restrain the board from continuing the inquiry proceedings commenced under the provisions of the Act. The exercise of statutory powers is stayed by this honorable court. The stay orders give a free hand to the writ petitioners to continue to function without setting right the violations of the SEBI credit rating agencies regulations, various SEBI circulars, and statutory provisions the investor's interests are without protection. As I said, no prejudice is caused by the mere rejection of settlement because there is already a remedy by way of a statutory appeal. I'll just make a few submissions, very few. I'll take 5 more minutes after lunch.
May I make a submission, my lord?
This case, which is going on.
Yes, item number 53, my lord.
No, we are thinking of 50. 50 is going on.
I'm not appearing in that matter, my lord. My name may be removed. I was waiting for that submission. 53, my lord. I am shown as R4, respondent number 4. And the department panel counsel is appearing, my lords.
Yes, we'll pass an order when it is called. Fine.
Obliged, my lords. Court officer? ಅದೇ 53 ಅದೇ ಕೋರ್ಟ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಮತ್ತು ಈಗ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಕೌನ್ಸಿಲ್ ಅಪಿಯರ್ ಮಾಡ್ತದೆಪ್ಪ. ನಾನೇ ಕೋರ್ಟ್ ಫಸ್ಟ್ ಕೋರ್ಟ್ ಅಂದ್ರೆ ನಂದು ಡೈರೆಕ್ಟ್ ಮಾಡಿದೆ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಅಂದೆ, ಮತ್ತೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇದೆಪ್ಪ. ಬರಬೇಡಲ್ಲ ಸರ್, ಇನ್ನೊಂದು ಯಾರಂದು ಗೊತ್ತಿಲ್ಲಪ್ಪ. ನಾನು ಬರ್ಬೇಡಲ್ಲಪ್ಪ. ಆಫ್ಟರ್ನೂನ್ ಸರ್, ಇನ್ನೊಂದು ಅಪಿಯರ್ ಇನ್ ದ ಆಫ್ಟರ್ನೂನ್ ಸರ್. Yeah.
Right. Just one clarification.
What? We'll see, ask your colleague to make a mention. We don't know, we have not been told. It's on, Mister, it's on only on, it's only on vacating stay. We are not deciding it finally. He knows, Mr. Vijay Shankar also knows. How can, we have not been told? He did not tell us. No, not morning. Please, I mean, ask your colleagues to make a mention when the matter is called. We will accommodate if you are busy. Right? He is arguing now. Yes, Mr.
Just one clarification.
So we have one clarification from our side also, that we are passing orders on vacating stay only, not deciding it finally.
No, we are interested in the vacating stay applications being allowed.
So, or if you want us to decide, and then I mean, I don't know.
I leave it to your lordships. I leave it to your lordships.
No, because in that case we have to hear the petitioner.
No,
we have not heard him.
No, these are ex parte orders. That is why we are requesting it, lordships.
Yes. So,
no, just one clarification. If your lordships are pleased to take the compilation, the two applications for vacating stay.
Yes.
Please go to page 158.
158.
158. This is in WP 124.
Yes.
IA number 2 in 12482. The prayer is that this honorable court may be pleased to vacate the order dated 13/7/2021 as corrected by the order dated 30/7/2021, restraining the respondent from cancelling the certificate of registration. That is the prayer in IA number 2 in 12482. Then, my lord, if your lordships are now pleased to go to page 165. This is IA number 1 in WP 14590. Please to vacate the order dated 11/8/2021. That is His Lordship Justice Dinesh Kumar's order, granting ad interim stay in respect of the letter dated 30/7/2021, by which the respondent communicated its rejection of the petitioner's settlement application. These are the two applications. Then, our writ appeals, kindly look at this also. Your lordship will perhaps need to be informed of this. Our writ appeal, first writ appeal is 1276 of 2021. 1276. In that, my lord, the prayer column is at page 25.
So you have challenged the interim order dated 11/8/21.
Please. That is in one writ appeal. And in the other writ appeal, that is 1283.
13th July and 30th July.
Culminating in 18/11/2021, which says the court has no time. These are the two writ appeals prayers.
Yes.
That's all.
May it please your lordships, Lord.
Yes.
For the writ petitioner. Lord, now that your lordships may not have indicated that the hearing is confined to the interim prayer, Lord, I will also bear that in mind while I make my submissions. Because the application for Lord implement of Union of India, which I mentioned on day before yesterday, I find in the list that is not shown, Lord. Probably it is there in the list, but that could be considered later also, Lord. That won't come in the way, Lord, of hearing the interim prayers. Lord, certain facts are necessary, Lord, for me to take your lordships through. If your lordship doesn't mind taking writ appeal 1283. There are 2 volumes in it. I am referring to the first volume. But I am a credit rating agency. The SEBI, my lord, has initiated certain proceedings against me. I'll, my lord, state what my main contention, my lord, is, so that your lordships will, my lord, be able to appreciate the facts. My main submission is this, my lord, that in the first writ petition that I filed, 12,482 of 21, where the learned single judge, my lord, granted an interim order on 13th of July. The main contention, my lord, was, there were twofold contentions. The first contention was that they had issued me a show cause notice. There was an inquiry. Following that, my lord, there was an administrative warning that was given to me. We thought it ended there, but it didn't end there. They continued the same proceeding by another notice. And in the meanwhile, my lord, I made an application for settlement. Not the settlement is a no default settlement. It is not a settlement where we say I am guilty and therefore I am compounding the offense. Now, my lord, the regulation 8 of the settlement regulation says that when an application is pending before the SEBI for settlement, no further proceedings can be taken by them. That was the ground on which, my lord, I approached the honorable single judge. And the learned judge, my lord, granted an interim order. Your lordships will find that interim order, my lord, in the writ appeal papers at page number 28. Now, there was a small error, my lord, in the first order, because the order was dictated granting stay, but it was not found in the order. Page 29 is the text of the order. That's in writ appeal 1283. 1283 at 29. In the first paragraph, my lord, the learned judge last sentence says there should be an interim order restraining the respondent. Then issue emergent notice. Then, my lord, at next page 31, the learned judge, my lord, notices that there is an error in the transcription and satisfied himself also from his own notes which he had made, and then made it clear that interim order was granted. The interim prayer, my lord, in the writ petition, your lordships could go to, my lord, page number 58. At 60, the interim prayer in the writ petition is there, 60. Stay the proceedings in relation to the show cause notice of 7th June. We relied, my lord, on regulation 8.2 in the compilation which my learned friend has kindly provided to your lordships, my lord. At page 20, this is the compilation of, my lord, all the statutes and certain other documents. Kindly go to page 20, my lord, 20. Regulation 8. The filing of an application for settlement of any specified proceeding shall not affect the continuance of the proceedings, save that the passing of the final order shall be kept in abeyance till the application is disposed of. Where the application is filed in case of proceedings that may be initiated against the applicant, such proceedings shall not be initiated till the application is rejected or withdrawn. So this was the main ground of attack, that this regulation prevents the SEBI from going forward. But they're still continuing to issue me show cause notice, my lord. There should be one notice at page 65. There was an inquiry report. There was a finding of inspection at page 100. We had submitted a reply. It culminated in an administrative warning at page 335, my lord. Sorry, volume 2, my lord.
(332), 335.
Yes, my lord. Page number 335. Lordship has not 335. The first two paragraphs not relate to notice, etc. Para 3. Upon analyzing your submission, the following discrepancies are observed in the sample selected during the inspection. Failure to disclose details of so and so, delay in disclosure non-accepted rating, delay in periodic review, delay in disclosure of press release, failure to check the conduct of the rating advisors. Then not further deficiencies in the next page. Para 5. What steps we have to take? Take corrective action. Yes. Then, my lord, page 351 is the...
Was that settlement application filed?
Yes, my lord. The settlement application, my lord, was on 12/3/21, Annexure Q, page 423. So they issued me one more notice at 351 on 17/11/20. Exactly the same issues which they had addressed. It's a long notice, my lord, so I'm not going to trouble you also with the contents of it. Then, my lord, we asked for inspection of some records. Annexure K, page 363. Because they referred to so many things in their notice, of which we had no access to any of those things. At 364, my lord, they permitted me inspection, limited inspection. After the inspection, I asked for certain documents at 365, my lord. Annexure M, page 365. Second paragraph. We state that at the time of inspection, we were informed that our request for documents was too vague and too broad. Rather than provide us access to files, the officer concerned with the SEBI requested us to make individual requests for documents. These requests were made orally at the time of inspection, post which it was communicated to the undersigned that in order for us to inspect these documents, the undersigned would have to submit a formal written request. Accordingly, we hereby write to you to kindly grant us inspection of the documents outlined in Annexure A to this letter on urgent basis. You will please appreciate these documents are required for our client to send a reply. Then we give all the details. Annexure N, at page 368, they send a reply giving us some information. And some documents, my lord, at page 375, your lordships will see the inspection proceeding. They gave us two documents, that's all. Inspection report. It was at that juncture that I made the settlement application at 423. The typed copy is at 424. Then they give us a hearing notice for the main show cause notice. That is at 616. Annexure R. 614. It was at this juncture we approached the Honorable High Court. Our contention around the writ petition is that this proceeding subjects us to two jeopardies, and Regulation 8.2 we relied on, and documents were denied. The learned judge, my lord, granted an interim order as if to rub salt into the wound. They passed an order rejecting the application, which, if your lordship doesn't mind, my lord, taking WP 14590 of 21. My lord, before I take a lordship through the subsequent events, my submission is today, my lord, the methodology that they tried to follow is would shock anybody's conscience. Natural justice requires them to give me all the documents that I require. That is not given to me. And secondly, Regulation 8.2 was staring at them in their face. And they did not, my lord, they dare not do anything further. How could they proceed with the adjudication was the question. So the learned judge, my lord, in my respectful submission, was completely justified in granting stay of proceedings. After all, it's a prima facie case that the learned judge found. And now, my lord, the appeal against that order is before your lordships. My submission, my lord, is there is nothing wrong with that order which calls for interference in an intra-court appeal. Any subsequent event, my lord, the subsequent events I will now come to, my lord. Now, your lordships, my lord, I've noticed this in many cases, my lord, that an intra-court appeal from a discretionary order is not to be interfered with unless there is something basically wrong, my lord, or there is some jurisdictional issue that is involved, or a point of law, my lord, which could never have done like that. Now, my lord, in this case, we are not in that situation. So, my lord, the great attempt that they are making now to challenge the order granted in writ appeal 1283, the order of the learned single judge, is questioned. Now, my lord, so much is said about urgency, this, that, everything. Lord, please notice that these two orders were passed on 13/7/21. They filed the writ appeal on 23/11/21. And now they're making a crying horse about delay. They filed an application for condemnation of delay, and thanks, my lord, to the general orders passed by the Honorable Supreme Court and by your lordships, delay was not pressed by them because there is now no delay because of the extension granted by the judicial orders. So what is it that they're talking about? This 37 till 23/11, they did not lift a little finger. Then, my lord, to compound matters and to show the manner in which this vindictive action is being taken by them, your lordships may now, my lord, take WP 14590. Well, what they did, the laconic order which they passed at page 37, Lord, it will not pass muster by any standard, my lord. Mohinder Singh Gill says, whatever reasons you have to put it in the order. This is a rejection of my application for settlement. It says nothing. Page 38, my lord. It is dated 30th July 21. Interestingly, my lord, it is passed on the same day that the learned single judge granted stay. It's as though they are calculating to make that writ petition infructuous by passing such an order. It becomes apparent and obvious. I've said so, my lord, in my second writ petition. Nothing is stated in this, my lord. Only reason given, para 2, this relates to default under regulation 5.2, is of the opinion that not considered for settlement since it falls under factors of 5.2. Your lordships have seen 5.2, my lord. My learned friend has read it, my lord, on more than one occasion. 5.2, my lord, talks of now, how does this authority come to this conclusion, which affects my civil rights, without any kind of hearing, without notice, and without any material. In the compilation of my learned friend, it is at page 18 now. 3 factors. If I were the adjudicating authority, if a settlement application had come before me, I will apply my mind to the settlement application and full stop. That's it. Because nothing else is before him. If there is something else which is before the authority, which that authority is going to consider while disposing this application, natural justice requires that they should tell us your application is received. There are the following matters which makes it prima facie looks like you are not entitled to this relief. Please say what you want to say. Nothing whatsoever. No notice, no hearing. And my lord, he reaches an opinion because the settlement, this regulation 5.2 says, my lord, it uses the word opinion, my lord. Kindly notice, my lord, in paragraph page 18 of the compilation of my learned friend. I'm sorry, my lord, I'm going back and forth, but I really have no choice, my lord. My apologies. In the memo of the compilation which my learned friend has given.
Yes, yes.
Page 18, 5.2. 5.1 says, application if received, what should happen, etc. Then 2, my lord. Board may not settle any specified proceeding if it is of the opinion that the alleged default has market-wide impact, caused losses to large number of investors, affected the integrity of the market. Now, my lord, let's examine that now. I am a rating agency. I am not a fly-by-night stockbroker or somebody who did something and ran away somewhere. I am a reputed company and I have a presence in the market. I am regulated by SEBI, no doubt. But the rating agency, my lord, what the rating agency does is, my lord, whenever securities are issued by any corporate body, the SEBI regulations require that the rating of this company, my lord, your lordships might have seen in the newspaper, my lord, A plus, AA, AAA plus, AGS, that means government securities, like this, backed by government, like that. These are different rating ranks are there. So this rating, there are many rating agencies. A company which is issuing securities or scripts, it should go to a rating agency, give their financials. The rating agency will then not look into the credentials and everything else. All the relevant parameters has to be seen. And then, my lord, they do a rating. Now, my lord, we have a similar thing for educational institutions. The National Accreditation Council, NAC it is called, it accredits universities and grades them. It accredits colleges and grades them. So this is like an agency. Now, my lord, if I have in 1 or 2 cases, I'm assuming everything against me. I have an answer, my lord, on merits. I'm not troubling your lordships with that. Assuming I have no case on merits. The allegation against me is that I did not do proper due diligence when I issued a rating certificate for 1 or 2 companies. That's the allegation against me. Let me assume it to be true. Now, if you apply these 3 tests, caused losses to large number of investors, nobody's case. Nobody has complained. Nobody has said that, look here, on the investment grade that this petitioner company gave, I invested 1 lakh rupees in this company. It now turns out that the company is a dud company and I lost 1 lakh. Therefore, you have to make good the loss because you have given me that certificate. I've relied on your certificate. Action in tort, whatever it is they want to file. No one has filed it. There's no such case. No allegation against me also. Then affected the integrity of the market. What is the meaning of that, my lord? How did my rating or my so-called bad performance of a rating agency, how did it affect the integrity of the market? Who complained? What happened? Then market-wide impact. On whom did it have an impact? Which are the companies which I rated, which went bust? My lord, supposing I rated 10 companies. Out of 10, my lord, 8 companies, after raising huge sum of money, the promoters ran away, the company went into liquidation, all the investors who invested crores of rupees, my lord, went home crying. Then it is possible. These are the 3 factors. Now, my lord, my submission is only this, that the manner in which they disposed of this perfunctory manner, my lord, indicates something more to it than meets the eye. That my submission, my lord, is that this is not how, my lord, and a body, my lord, like SEBI should conduct itself. It should act fairly. It's a regulator. is this fairness? Now, my lord, law is well settled that when this provision is silent regarding hearing, it is implied in it. Unless the regulation or the rule or the law itself says that no natural justice, no hearing. Not many cases we see, my lord, no hearing is there. Like, for example, not rule making. When rule making power is given, it will say objections to be filed, and the authority will consider the objections and pass an order. There's no question of hearing everybody who wants to file objections. That's how it works. Now, if it is excluded bind, here it is not excluded. Now, my lord, compounded to this, kindly now see sub rule 5, my lord, at page 19 in the same compilation. Now, this gives unbridled power. Page 19 in the same compilation. You can cut off anybody's head without hearing. You can pass any order. You can disenfranchise this person. You can say that either this rating agency and its promoters and its directors, nobody should have anything to do with the stock market. And all that can be done, just like, my lord, a dikkat. Nothing shall construe to restrict the right of the panel whole-time member to consider or reject any application in respect of specified proceeding without examination by the internal committee, high-powered advisory committee. Now, the regulations provide, my lord, that there is a procedure for all this. This is a Ganga clause. By this Ganga clause, page 23 may be seen, my lord. What is this high-powered committee? Why did they constitute it then? The regulations provide for a constitution. This is a draconian power, my lord. Even Napoleon was little more considerate when he used the guillotine. He heard the wife sometimes. And after hearing her, if he was convinced that the husband was a bad man, he said, let the blade fall. But here is nothing like that. They have their own bodies. You ignore everything. My lord, my submission is this is a completely unguided power. Therefore, my lord, I have left with no option but to challenge it. Now, my lord, I come to what is the order that was granted by the learned judge. The learned judge said that this Annexure C rejection should be stayed. Now, my lord, it is in the context of this background of facts. Now, my lord, in this submission, lord, my submission is against this order, there is a writ appeal. Now, my lord, what is their contention in that writ appeal? The challenge in the writ appeal, my lord, interestingly, is to the order refusing adjournment. If your lordship sees, or rather granting adjournment, writ appeal 1276. In writ appeal 1276, they have challenged the order of 11/8/21. Your lordships will find that at page 27. When ad interim order, page at 28, I'm reading. Now that the writ petition is before your lordships, now, my lord, in the division bench because of the challenge, my submission, my lord, is that this writ appeal, my lord, does not survive because there can't be an appeal to the division bench from a proceeding in which the division bench itself is hearing the matter. So this writ appeal 1276 would not survive. Now that the writ petition from which this order was made was before your lordships. At any rate, my lord, the order passed by the learned judge, my lord, on the facts of the case in my respectful submission was fully justified because, my lord, the ground of attack was what, my lord, impressed the court. The court, my lord, examined that issue and came to the conclusion. My lord, the grounds that I've raised, my lord, I'll just mention them, my lord, I won't trouble your lords with reading them. Annexure C is bald. It doesn't consider anything. It's illegal, vitiated by legal malice. because the dates are a telltale, my lord. 37 interim orders, actually interim orders granted earlier. It was only clarified on 37. So they wanted to pull the rug out of below the feet. And they seem to have passed this order in great haste. No hearing, no application of mine. No, they can't substitute their reasoning with anything else. Natural justice. Now, my lord, in a case like this, my lord, my respectful submission is the order visits serious civil consequences on me. I have, my lord, large number of workers, staff who are working with me. I'm a big establishment. The only business that I'm doing is this rating. I have a large clientele. It's a question of my name, my reputation, everything. Can it be dealt with in such a cavalier manner, my lord, by the SEBI is a question, my lord, I ask SEBI. Now, in these cases, my lord, ultimately, your lordships will have to, my lord, lay down the law as to what is the interpretation of 8. And is such an order passed in such a manner a tenable exercise of statutory legal power? Therefore, my lord, my respectful submission is that pending, my lord, the hearing of the matter, these interim orders, my lord, after all, my lord, the heavens are not going to fall, my lord. There was a lady, it's now in the newspapers, SEBI was, my lord, closing her eyes when some yogi was giving her instructions. Now she is happily in CBI custody. I'm not in that league. I'm very small fry. I don't know why they want to use not a nuclear weapon to kill a small ant. I'm such a small, tiny person, my lord, in this whole scheme that SEBI is regulating. And it is in its context, my lord, that I'm submitting. There seems to be some attempt to act in a vindictive manner. And the impression that we have, my lord, is that this is done at the instance of some third person who is, my lord, our competitor. And SEBI is unwittingly, my lord, allowing itself to be used for that purpose. Therefore, my lord, the ends of justice I respectfully submit require interim order may be continued, my lord, and the matter could be heard. I'm deeply aware.
I have two clarifications.
Yes.
The order dated 30th of July 2021. The earlier order was 13/7/2021. Now they make an application for advancing. On 13/7, the date given was 2/8. Kindly note that 2/8/2021. Now they have the case advanced without notice to us. Then on the 30th of July, that order is made. When SEBI made this order, the SEBI was not aware that on the same day, this interim order had been modified. There's no question of the expression that my learned friend used, pulling the rug off with the feet. No, no. We were not aware of it because the original date was 2/8. Then, my lord, the other clarification is, my learned friend didn't refer to these applications. Please see that the applications for vacating have been filed within 30 days from the date of the interim orders. At page 158, we are seeking vacation of 37/21 order. That application is filed on 13/8 within fortnight. Then IA1, it is to vacate the order dated 11/8. The application is filed on 7/9. But I'll just conclude by again emphasizing that the Act, my lord, empowers the SEBI to proceed further. That process, statutory process, has now come to a standstill.
Yes.
That is impermissible.
My lord, with your lordship's kind leave, my lord, just one line, my lord. I had filed that application, my lord, for delinking. I'm just drawing your lordship's attention to it, that's all.
All right.
Our submission was that the first repetition should be for the learned single judge. That was
But we have filed objections to that.
Yes.
Yes, my Lord, if it's assisting your lordships, my Lord, a small synopsis is got ready, but can I request the instructing lawyer to file it? Facing some internet problems, I think.
Then all these, only these, don't mix it up.
Only this much.
Otherwise, we will come out there. Keep it along with notes.
Yes.
Yes. Further, he went away saying 1 hour. Huh? Here was some other matter. He won. He's taking us for granted, right? Like doing for a while and then. Yes.
Because Mr. Naganand's connection is he just messaged me saying he's lost his connection, my lords.
All right. Yes.
You have got anything to add?
No, my lords, Mr. Naganand has covered all the arguments. my lords.
Yes. Okay.
I think he's back, my lords.
Yes.
Mr. Naganand, sir, you're on mute, sir.
Sorry, my lord.
Your colleagues have told
lost internet connectivity. My apologies.
Mr. Naganand, your colleague told some of this thing, Mr. Lakshmi Narayan, that he will take an hour. So he has gone away. He was arguing a partnered matter. He said he will take an hour. We told him that we have not been said.
45 minutes, what I told him, Lord, and I've taken 45 minutes.
Okay.
Sorry.
All right. Yes. Next.
That synopsis may be not permitted to be filed.
Yes.
It is filed.
Okay. Yes.
There are some cases on the point also, my Lord. It's all taking cold to Newcastle. Just for your immediate reference, my Lord, I made that also.
All right.
On natural justice angle only.
Your background has changed. My Lord has noticed. Yes. Okay.
What happened, my Lord, was there was some problem with my other laptop on which I am working.
Okay.
So I used another alternative.
Yes.
Grateful.
And next.
Number 51, Sri Syed Kamruddin, government advocate.
Yes. What is the review?
Then not notice to me. It was also on by expressing the fact that there was a matter already pending in the Supreme Court that suppressing that one decision.
Learned Senior Counsel for the petitioner. Learned Senior Counsel for the petitioner submits that the order dated 19th of July 2021 has been passed by division bench of this court without notice to the appellant. It is also submitted that the respondent number 4 did not bring to the notice of what respondent number 1 did not bring to the notice of the court that the matter is pending before the Supreme Court, right? In view of a court's submission, issue notice to respondents. Emergent notice. Notice on behalf of respondent number 2 is accepted by learned additional government advocate. So who appears? In addition, that so and so learned counsel for the review petitioner shall be at liberty to serve a copy on the counsel who represented respondents number 3 and 4 before the division bench. In the writ appeal, in writ appeal, in writ appeal, that's all. Before that, you write IA, one of so and so is dismissed as dismissed as not pressed. This will be the first sentence, right? Thereafter. What? Maintenance. What husband or what wife? Husband. So 10,000 each to
Wife and 2 children.
Totally 30,000. 30. What is? Have you filed the objection, Mr. Last date you were granted? What short date? 17th February. Now it's nearly one month. No. 17th February also time was granted to you to file objections. Signature where it has gone. Even if it has gone to US, it would have come within 24 hours, right? Within 5 minutes. Why do you need 1 week? So that's what we are telling you. 17th February time was granted. It's nearly 1 month, right? Communication gap. Between whom? There is always a communication gap between the court and the counsels who appear, right? Huh? What? Huh?
Not just 10,000, Mr. 30,000.
30,000.
Yes, you have not
So
produced any material before the family court proving the income. Absolutely zero. There is no document to prove the income.
he is also very poor. That's what you see. So we will decide who is poorer and grant. What is this? Why do you take things so lightly? 17th February you are granted time. Have you told us why within 3 weeks you could not file it? Have you told us? Nothing. Or saying all sorts of things. Communication gap means what? What communication gap? Whether the court is responsible for communication gap. Then, and what is the material which you have placed to show? What is his income and how much should be granted to you? Saying that you could have said 5 lakhs. Why more than a lakh? Say 10 lakhs. It's just a matter of saying no. What is the material, mister? What is the material which you placed before the family court? Nothing. That's what my lord pointed out. It will depend on his income, right, and number of dependents. So why should we grant you time? Tell us. That's the reason precisely why we this thing. Why 3 weeks you have not done anything? Warrant is granted. A week's time by way of indulgence, failing which appropriate orders on IA 1 of 22 shall be passed. Now it's your choice to do it or not to do it. Now there should be no communication gap, right? No communication gap, right? Clear? List on date. Some date. What date? 1 week is 17th March. No, 1 week is 21st March. 21st March. Yes.
Number 53, Srimati Tanmay Rajkumar, government advocate.
Somebody else is appearing for respond number 4, right? Revenue Department. Who is appearing?
KVR. Department of Revenue. Final. Union Article.
So validity of section 3. What is it?
ASGF. Was made that ASG is appearing.
ASG is appearing.
Providing these services and to supply set of box. Set of box might collect something as activation charges, basically to activate the services of the entire consideration, the petitioner has paid services at the rate of 12.5. Now the state says that there is a sale of set of boxes by way of right to use, transfer of right to use. Therefore, this activation charges which has already suffered service tax should be subjected to sales tax. So my limited relief in the repetition is not easy. Simply, I have discharged tax at a higher rate. I have paid to the service tax department to the central government. My understanding is that it is service. Now the state says, according to me, it is service because cable television services figure as an acceptable service under Finance Act 1994. So union is saying with me because I have paid taxes to you. Now, to levy tax. If you have come to the conclusion that it is a state, then the service tax that I have paid is collected without authority, and that has to be refunded. In fact, I would be beneficial if the merchant say that it is a sale because I will get 7% back from the union. Now, in fact, now it's identical issue in somewhat different context in the sense in mobile telephone operators. There is a SIM card is given for activating the mobile telephone services. The one thing the Supreme Court says that during the course of supplying service, if you give a SIM card, something to activate the service, there is no say. Matter according to is directly covered by the Supreme Court judgment. You have to kindly see the case for combination. Judgment of the order. I just think one by one. Page 35. Page 38.
No, there is no pagination here.
Page 38.
Yes.
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 Service provided and the dominant position of the transaction is to provide services and not to sell the material that is required, which on its own, but without the surveys, would hardly have any value at all. But if I just sell the set of forms, what is the value to the customer if I just give the set of? We have no value without the services that I provide. The honor is that if the entire set of forms that I provide is
Identical matter earlier. Identical matter was there. We had heard it first.
So similar controversy has been pending. Where is that?
That is at page 1 and page 1.
Page?
The first order is at page
Violation.
Page 1. Page 5 is the first order. Page 1 is the second order. Sufficient of the application that the department state government made the file and memo of the department.
Similar matters were also before the division bench.
Now these matters which are earlier filed have been answered.
No. There was a matter when I was part in other division bench. I have, yeah.
There are some matters which came from the here. Additionally, what I am trying to note is after the
Where is that?
state has filed on along with an order passed and here.
All right, madam. Then, yes.
I have paid 12.5.
Paid. Yes. No, in similar matters, yes. Mr. Oh. We can.
For maintaining an appeal, I have to necessarily deposit 30%. That 30% which was paid was for filing the appeal in the before the first appeal authority and the second appeal authority. All that is also said that the remaining shall be settled by bank guarantee in that case. Here, I am challenging the constitutional validity itself. Therefore, I have opposed your lordship directly. And I have also made union a party because ultimately, according to me, it's a dispute between the state and the union. They will have to decide whether it's a sale or a service.
Yes. Yes, madam.
If ultimately the matter is, even if the matter is held against me, I have to gain 7% from the get refund of 7% from the center.
Yes, a debatable question. Yes. Mr. T. Suryanarayan, senior counsel with counsel for the petitioner. But on the question of admission as an interim leave, he should notice on behalf of 1 to 3 is accepted by learned additional government advocate. Office is directed to reflect her name. None has appeared on behalf of respondent number 4, though a copy of the writ petition has been served, right?
130, Mr. Madanand Pillai. He appeared
He said he doesn't appear. He is not appearing. Not appearing. None is present. Acha. Learned Mr. So and so undertakes counsel. What's your name? Undertakes to supply a copy of writ petition along with annexures to Mr. Niralgi of office is directed to reflect his name as counsel for respondent number 4. Heard on the question of interim leave. Learned senior counsel for the petitioner submits that the activity of providing set-top boxes as part of direct-to-home services. Services cannot be treated to be a sale under the provisions of Karnataka Value Added Tax Act 2003. Full stop. It is further submitted that the petitioner has already paid service tax on the entire turnover, which is in respect of which the demand has been made by the impugned demand notices. Full stop. In support of submission, senior counsel for the petitioner places reliance on decision of Supreme Court in Idea Mobile Communication Limited versus Commissioner of Central Excise and Customs, Kochi, 2011. Bracket close 12 SCC 608. Fine matter. 608. Right. It is also urged that it is also pointed out that writ petition involving similar issue has already been entertained and interim orders have been granted. In this connection, reference has been made to interim orders dated interim order dated 27th January 2021, passed in WP number 1534/21. Right. On the other hand, learned additional paragraph. On the other hand, learned additional government advocate has invited the attention of this court to an order passed by a division bench of this court while entertained in STRP number 31/2019, and has submitted that the petitioner has already deposited 30% of the outstanding dues and has secured and has agreed to secure the remaining amount by furnishing the bank guarantee. Therefore, the petitioner be directed to deposit some amount. Paragraph in view of aforesaid submission, learned senior counsel for the petitioner submits that the aforesaid amount was deposited as a by way of a statutory deposit to maintain the appeal under the provisions of Karnataka Value Added Tax Act. And since the validity of Section 3 of the Karnataka Value Added Tax Act in this writ petition is under challenge, therefore the petitioner cannot be compelled to make payment of the amount, as he has paid the tax in respect of the entire transaction. Full stop. Paragraph in view of aforesaid submissions and with a view to maintain parity, it is directed that no coercive action shall be taken against the petitioner for recovery of the amount under the impugned demand notice dated dated Madam 28/12/2021 annexure B till next date of hearing. Just along with
further hearing. Prashant here.
What's your name? What's your name? Don't write list tomorrow. They are making request from the order sheet. What we appears that we are adjourning. Right? Right. What's your name? Prashant PN, learned counsel for the petitioner, prays for adjournment on the ground that arguing counsel Mr. Lakshmi Narayan, senior counsel, is not available. List tomorrow or day after. Tomorrow. Again, he has matters at 2:30. What can be done? Yesterday also he sought an adjournment. Today also. Tomorrow. No, but what please? I mean, he has argued and then he has disappeared. So we are adjourning the case. No, this is please understand, Mr. This is this is a part-heard matter, deserves to be given precedence, right? He has to adjust in other and conclude. He said half an hour more. He said, how did it begin? You were there. He said, I will take 25 minutes. Now it's 1 hour more. 1 hour we have already heard it. No, this thing. Please ask him to give precedence to this matter. This is part-heard. It cannot go like this. You cannot do like this, that you argue in a court, all court halls 20 minutes each day and then appear at your convenience. So courts will keep on adjourning the case. It can't happen like this, right? No, don't apologize. Please tell him to conclude tomorrow. That's all the purpose. Tomorrow. But write the whole thing. Don't say list tomorrow. Otherwise, it happens that we are adjourning the case.
Final hearing?
You are complete tomorrow if he is not there. There's nothing. He has practically argued everything. You have to just give a list of submissions to us, which you have prepared. Give it to us, that's all. Yes.
Final hearing, number 55.
Yes.
That they should have factored out at state point. They did not set the budget at state point. There is no violation of the law. So the patent is directly where it had a getaway by the dereliction of duty. Because in between the state and the something is not permissible. It should be a stage one. Therefore, in effect, they indirectly have to get to reduce the charge. Charge of 4 and 5 feet has not been disturbed in effect because there is no discussion at all about what is undertaken. That is in the gravity of the enforcement punishment and that is by then without the quality is the end. And which without that is granted, the date of 2010 and the date of 2001. I think the date of superannuation in the month of the year 2001. Actually, all benefits are granted by the government. And the petitioner having obtained the CH-2 superannuation long back is entitled to 180 benefits. The entire order of business
Huh? 280. Yes.
Evidence that regard in case actually normalization was filed. There's also a proceedings for in this what is the argument? The government council for management produced the copy of the award and the item number 40 of the charge regarding the possession of money to the tune of 2005 the other charge that the first party colluded with the Petitioner in taking the business of which entrepreneur argued for a deal and then he asserted for the demand of the right way is also important. In other words, the charges against the first party improved by important aspects. Now you're also the part of the paragraph 11, page 18. of the other witnesses are eyewitnesses to the incident. MW has specifically admitted in the class examination that the amount was not demanded by the petitioner and the amount was demanded by the customer. It cannot be disputed that the petitioner party is taking back along with the customer. All the witnesses MW will be approved. But on the basis of the investigation, in this regard, the evidence of MW is very more than the other management. It's the witness in the start. No witness in favor of the petition will be gathered in the evidence. Regardless of any further, if you do that, it is a requirement of property. This is required, not beyond all this. Not only evidence that is first by the group and carries the money. Therefore, so far the demand of the driver of this concern, there is no evidence for the petitioner is concerned. The evidence against Parshurama cannot be attributed to the petitioner as far as the demand aspect is concerned. There is no reason to dispute the evidence was categorical activity in that examination. The petitioner has not demanded any amount from him. In the case of an illegal gratification, it is an essential criteria. There should be a demand and acceptance of the type of amount. They will put out of the there are 15 of the order. Evidence that not shown that the amount of money was specifically demanded in the petition. The office is correct and the ground. When you are party to take it, they will go procedure to vote that. And the probability petitioner voted with equal sign. So there is a solution to Karnataka being put against the petitioner. Further, the labor court observed in paragraph 15 of the order that the statute and the position of the other courts is to the tune of 50 to the applied, for which the first party is in the particular. The petitioner was acknowledged that the petition has position that it was produced as having declared personal money. The WW1 has admitted exhibit intensive program. Is further admitted on the day they proceeded via going into an which is not the actually likely program. Therefore, there is no necessary for the petition for process to exist and deviated the program. Now coming to the quantum of punishment, the exchange punishment of this service is therefore, including of good implement. With community of the mediation would be the labor court RPO, this is the decision of the inclusion of our RPO. There is a manual kind of including of two. The Parishram is the medium man. Even because this was brought in at the age of that was recently promoted, there is 3 months before we were. Now, this is very before the labor court, what happened was just the Parishram is concerned about that where the inquiry had to be there proper. Specifically, labor court found that there is no power to be decided, and the order of this it has not been the minority. Then in my case, there were not the domestic inquiry, the validity of the inquiry was done. The labor court after the basis of the inquiry, in my favor, the inquiry is not there proper. Then a lot of fresh evidence was used, management is examined, evidence for witness is examined. The important crucial witness is never MW the complainant. The complainant says that throughout even the first statement what he has made, saying that the demand was made by Parishram. I have not made any demand. Ultimately, demand and acceptance, nothing is whether the amount as well accepted is not forthcoming. Furthermore, the MW has categorically said the person who demanded the money didn't come subsequently and when though he has waited up to 7 p.m. or 2 the first time. Now, this was the evidence. Nonetheless, here is a case where the inquiry was there. In the domestic inquiry, the inquiry officer had charge number 1 and 2 on the basis of association of duty. Now, when the inquiry is invalid, the labor court found that charge number 1 and 2 also has been. Now, my respect of that finding is contrary to the evidence of MW3 and MW4. MW3 and MW4 says that regarding the possession of excess cash is concerned, there was a certification being come to control. and there is no violation of this section. That was the evidence before the labor court is unfortunate, where the labor court also specified that even the industry also not as confirmed the order made by the labor court. Now, my submission, you also the major charge leveled against me was saying that I demanded money. I also wanted, I was already the other checking fact. When the demand and acceptance has not been proved, the matter of vote law, the complaint himself comes to the labor court and says that I have not, he has not demanded the amount, he don't pay amount, even if in respect of the demand of the right by the other inspector. When settling the question, considering all this also to that. Let exercise the power conferred section because labor court has not power to examine under section 1 section 11. When the labor court has declined to do so, the signature rightly exercise the power conferred under section 11 and will not granted even the lesser punishment officer will report. This is the case there. The workman was dismissed from service on 22/9/2005. He was dismissed and he was retired from service on 2/1/2005. For 7 years, the matter was pending before the. Now, since he has retired, only he will get only the retirement benefit. Therefore, my respectful submission, rightly exercise the power and granted the relief, not against the law can issue the order of the legislature. So, with respect of the judgment cited by regarding the labor court cannot sit over and the American court cannot reappreciate the entire evidence. Kindly appreciate. The adjudication process under industrial code and an adjudication process under criminal is not different. Therefore, my responsibility against a case where adjudication of industrial is to that will not be evidence will be recorded, the findings will be there, but that is such a process procedure is not there in the administration. Therefore, my lord, that's a case where a dismissed employee went to the CIT and ultimately that is not the question here, but it's an altogether different. Now, on the other hand, my submission is the labor court not has committed a serious error in recording the findings saying that this not has been proved. My submission is the legislature, though he has not stated so, but it is a finding recorded erroneous and it's a finding, ignoring the evidence of the crucial witness and given evidence. Therefore, my lord, even under Article 227, when the labor court tribunals, kindly see 1964 Supreme Court, AR 1964, 84, 1990.
I don't know what.
What is the citation? What is the citation?
Citation. But it's not your appeal, right? But who's finding perverse? You are saying single judges are finding.
The single judge will not have signed that the findings of the labor court is perverse. No, he has not said so. But ultimately, the conclusion of the labor court is saying the single judges, the labor court went it wrong in not ignoring all these material evidence. Therefore, my respectful submission.
Yes, anything else? Get to her. The track, HM. Without but anyway back. Yes. Ah. Oh, it's over. Don't come again there after that. You forgot thereafter to say anything. Nothing happens. They won't do anything. It's sub judice. At your instance, it is being adjourned.
Physics. Sir, Swami.
So in that case, madam, write in order to continue. 54. Tell her that interim order should continue. It's coming up tomorrow. So it will not be continued to after tomorrow. With the understanding, right? That tomorrow, if you don't argue, it will not be continued. Okay. Lighter when we are saying. Nobody can see tomorrow. Yes. Which case?
Number 56.
56. Yes.
Council.
Counsel for respondent is not there.
Sumangalaya Swami.
It's not there.
Husband's petition dismissed.
Seeking divorce. So you want freedom, right? Yes. But counsel for respondent is not there. Password, please. Let's see.
Number 57. Sri Satish K. Sri Nishant Devi. Sri B.L. Sanjeev.
Will you concluded today, Mr. Bhagwat, right? If not, then we already have, the council is making prayer submissions in installments before us. So we don't want that situation. Otherwise, let it come tomorrow then. It will be repeated. Today. 21st. All right. Placed on 21st December 2020. Oh, sorry. 21st March 2020. Of course, please file. Yes.
Nine.
58, no?
Serial number 33. KDB matter.
Have you read that?
Yes, ma'am. Number 59.
58 has been adjourned. Not adjourned. That's why we should order. There is some other matter. No, we have not adjourned it. 38. What order?
Connect the matter with serial number 33, my lord. Lordship said it will not be connected, just it will be stayed.
This is not adjourned.
This is not adjourned.
We have only seen.
Yes.
3 we have issued notice and adjourned. We said we not connected.
Not correct. Yes. A question of delay has to be decided.
Yes.
It's a case where 4 years delay. Affidavit you have filed.
58. Same Nagpur government educate.
What happened? Then file the objection. Therefore, the signature is not filed. Given opportunity to file this.
Yes.
But the order was passed with your consent, right? Order was passed with your consent. Consent on both sides, matter is taken up. But Mr. You will agree, you can't dispute this proposition that eventually whether or not the notification, the notification has to be issued within reasonable time. What would be the reasonable time would depend on the facts of the case. Not take. They've issued a notification 28/4. No, 28/4 has been issued, right? And
not even when the matter was going on before the annexed in the date you are. 10 years ago, 17/6/2010, the matter was remanded for the land acquisition.
so where is Mr. Synopsis? Is there date list? No, synopsis. Where is synopsis? Where is?
File ಮಾಡಿದ್ದೀರಾ sir?
Just a minute. Statement 1st of February, 18th October. Yes, Mr. You have to basically meet the reasoning in para 9 and 10. There is nothing Shivanna and all that. You are, please read para 9 and 10 of the order passed by the learned single judge, page 12. What he says that, you cannot perhaps argue that even if the statute does not provide, you can do whenever you feel like. It has to be done within reasonable time, right? Please read para 9 and 10.
Should be the reasonable period in which the final declaration should be made, and in such
a declaration is not made within a reasonable period, the preliminary notification and all other proceedings of petition are quite required. Therefore, in the present case, having found that no declaration section 28(4) of the KIA Act has been issued by the state government, by the preliminary notification was issued on 16/7/2006 and by an order of the final notification 28/45 as on 17/6/2010 and the subsequent notification to section 28 was issued by the special examination officer on 2/2016 and notification to section 64 has been made. The court has no other option than to allow the repetition and start the execution proceedings. This is the notification date. Not exactly we are reviewing. Anything else? Dr. Code, these are those who have consistently said that the provisions of Land Acquisition Act and does not
No, that's what we are trying to explain, Mr. Probably, as we understand para 9 and 10, the proposition of law laid down is not that 11A applies and proceeding lapse. It's not that. The proposition of law laid down in para 9 and 10 is that when the statute does not prescribe a time limit for exercise of power, that power has to be exercised within reasonable time. This is, I mean, any number of decisions you will get. What would be the reasonable period of time will depend on the facts of the case. So it's not that 11A as applies and all that, nothing. The power. This is, we agree, we will dilute this that 2 years should be the reasonable period. That can't be done. But the question is, we will dilute that statement of fact that 2 years should be reasonable period. But what should be the reasonable period has to be decided on facts. Learned single judge having examined that after 4 years also you did not issue 28(4) as question. Now you may, we have told you what we are thinking, now you argue. It's not Shivanda and anything. Nothing. No, in this case, there is 4 years you did not pass. No, that may be a different thing. We will agree it is overruled. That is still, this law still holds the field that the statute does not prescribe the time limit for exercise of power. It has to be exercised within reasonable time, irrespective of Shivana or everything else. That the Supreme Court itself says, right? You cannot exercise after 20 years and say that no time limit is prescribed. We can do any time, any point of time. There's no explanation. 4 years, Mr. 2-5. So that's what that's what my lord pointed out. With consent, it was heard. The council did not say that we want to file objections.
Unless he is prescribed under the KI Act itself, that the notification needs to be issued within a specified time or within a reasonable time. That is what the Supreme Court has said. I am referring to a decision of the Supreme Court.
No. We would, you read whatever, but what is the proposition of Apex Court that any time it can be issued?
Consistently, the Apex Court has said that the rigor of limitation prescribed under Section 6 cannot be applied to special statutes.
Of course. No, yes. We are not saying that it should do it within 2 years and 11A applies, it will lapse. Nobody is saying. We are on a broader legal proposition, which as a senior counsel, you cannot also dispute that if the statute does not prescribe a period of the time limit for exercise of that power has to be exercised within reasonable time. What would be the reasonable time would depend on the facts of the case. We are not saying this all we told you in the beginning, without you arguing, we told you that we will dilute this statement of law that it has to be done within 2 years. Nothing. No 2 years. If you are able to tell us 4 years was, this is what, these are the circumstances, why there was a delay, we will say that yes, reasonable explanation has been given for exercise of powers after 4 years. Ah.
Final notification had already been issued once in 2010. Kindly appreciate this. But notification had already been issued. And the instance of the petitioner, it was not what in the year 2010. Thereafter, the already put directed that the inquiry to continue on Section 28(3) and matter to proceed.
So you have passed 2/5/2016. You had passed.
Yes, I have passed the order. It was sent to the government. It was pending with the government. Kindly appreciate, this is not the only pocket of land is not acquired. It is part of the 4800 notified. And what will also kindly appreciate, now the final notification has been issued and it is not under challenge. How can we not be petition is not allowed to stand in the face of the final notification, which is not challenged before the government?
No, do you want to say that that final notification is outside the, is it not subject to result of the appeal? You do, I mean, you obtain stay. We have granted stay, and you issue a final notification, and they say that now this court can't do anything. It is also, this is all subject to whatever you have done, whatever he does. Supposing if he dispossesses you and raises a 5-story building, so can we not order demolition, saying that during the pendency of this writ appeal filed by you, he has dispossessed you and has raised construction of a 5-story building? Can we not order demolition? Everything what you have done is subject to result of this writ appeal. Please. All right, we will decide this.
I want to
After this court has said that the decision has lapsed. There was the question of issuing point of
Stay. There was a stay. So that's why on the strength of the order of stay, they have issued 28/4, say that now it influences. How can this be? The order passed by the learned single judge remains in existence. It is not obliterated. It is only stay for temporary suspension, right? Stay and you understand the distinction. We will deal with. We will record. What is the final notification date you have mentioned here? 4/11/21.
Let me check copy of that.
It is filed along with memo. Yes. No, of course. No, nothing. It's not that we are not permitting you to argue. What we are saying is we have disclosed our mind. We should be fair to you, right? So that you can meet what is going on in our mind. That's why we told. Not that. Please argue. We agree. Which we agree with that. What is the citation? 2006. Para 2006-7. Page. Yes.
That there was a delay of books and money and 10 months in publication of the second notification. As I already discussed, the scheme of the present is different, and there is no similar provision like the one contained in the provider of subsection 1 of section 6 of the Land Acquisition Act, which is take out a period of limitation of 1 year for making a declaration on section 6 of the Act. In the absence of any specific provision to that effect in the Act, and the land we are being not full of.
This is also not very long. Yes. Please, by all means, we are not prohibiting in any manner, Mr. We have frankly discussed with you what is, we are not preventing you. Please argue. Please, we will hear you. Don't be on. All right, please. Yes. Please proceed in your own way. There's no prohibition. We just, because we heard it on that day, we are telling that this is a fine. Go ahead. Please. All right, all right. So first, let us finish this. The decisions. Then, what other case? Yes. Yes. No, no. Yes.
It was contended here in Karnataka state also there was delay of more than 5 years in issuing the final notification. For contended on behalf of the landowner that there was undue delay in completion of the land acquisition procedure and for more than 5 years the final notification was not issued. The writ petition filed. There was undue delay even if the period of 2 years of time being provided under the LA Act does not apply for issuance of land. It cannot be today in making steps. The acquisition does not have to be kept in large for more than unreasonable period and done in the instance case. Thus, the High Court was fully justified in watching the final notification. When more time has been fixed under the PDA Act to complete the issuance of final notification. And it would not mean that we can unreasonably delay such steps can be taken as there was restraint put upon the owner by issuance of the right to enjoy complete property not have been denied for an unreasonable period. I saw this very complex character. First, we take up the question that whether the High Court was justified, legally justified or merit in watching the prisoner. The range of this court in October has decided the question accordingly. The EDA has issued treatment policy. That period demotified and the permission we got granted earlier was withdrawn. The demotification of the land was also withdrawn. It was further that the time frame which was prescribed under section 6 and 11A of the India Act would form an integral part of the DDA Act. This court considered the key under the DDA Act and has observed that They are section 6 and 11A of the Land Acquisition Act. As per section 11A, if the award is not made within a period of 2 years from the date of declaration in section 6, acquisition proceedings is that. Similarly, a declaration in section 6 of this act is not issued within 3 years from the date of publication of notification of the Land Acquisition Act. Such notifications being issued after the commencement of Land Acquisition Act remain in validity for 1967. But before the commencement of Central Act 68 of 1984, after 1 year, a section 4 notification was published subsequent to the public of Central Act 1968 of 1984. The declaration in section 6 of the Land Acquisition Act can be it is clear that the BDA Act is self-contained code, which provides for all the stipulations that we arrange in land development of an area, including the acquisition of the act, does not indicate any necessity for using the provisions of section 6 and section 11 of the Land Acquisition Act as part and parcel of the BDA Act, not agreement or agreement of object. The primary object of the state act is to carry out land development and acquisition is the nearest incident of such land development. Land is required for specific reasons. And acquisition means the sum and substance of the act. All matters in relation to the acquisition of land will be regulated by the provisions of state act has provided its own fees and provisions for acquisition of land. Like I hope principle is the provisions relating to acquisition like parting of and bought, payment of compensation and legal remedy available under Central Act state act. But the law contained in section 6 and 11A of the act cannot be made use part of state act, and the state act itself has provided specific time frames under its provisions as well as content. The state does not need such incorporation. The principle stated in Uniform states that the BDA Act is self-contained code was referred with the 2000 the code area typically discussed and answered the question whether the provisions of section 6 of the Land Acquisition Act apply to the petitioner of the BDA Act, and if the matter declaration is to move on is not issued within 1 year of the publication of the notification. Arises from the contention raised by one of the claims that the provisions of section 6 of the apply to the BDA are at notification in 71 and 3 of the Act was issued and edited on 3/2017. Section 91 issued and published on 23/2004. Section 26 of the Act provides that the acquisition of land under the BDA Act within or outside the landlord metropolitan area shall be regulated by the provisions of the BDA Act. BDA Act requires that notification shall be made in respect of any land covered by notification after the expiry of 1 year from the date of the publication of such notification. And the provisions of the BDA Act shall be made applicable to acquisition. It is necessary that the declaration of section 21 of the BDA Act, which is equivalent to the final notification, should also be renewed before before the expiry of 1 year from the date of publication of notification of the 1 of the BDA Act. The BDA Act contains provisions relating to acquisition of up to the stage of publication of final declaration. The Act does not contain subsequent provisions relating to the completion of acquisition, that is, issue of notices, inquiry, and reward, vesting of land, payment of compensation. So the BDA does not make the LA Act applicable in its entirety, but states that acquisition under the BDA Act can be regulated by these provisions so far as they are applicable of the LA Act. Therefore, it follows that where there are already provisions in the CA Act regulating certain aspects or stages of proceedings, the corresponding provisions of the LA Act is applied to the acquisition under the BDA Act. Only those provisions of the LA Act relating to the stages of acquisition for which there is no provision in the BDA Act are applied to the acquisition under the BDA Act. The BDA Act contains specific provisions relating to and final procedure. Up to the final declaration of the BDA Act in reference of procedure under the LA Act to a stage of final procedure. Therefore, having regard to the scheme for acquisition, to 19 of the BDA Act and the limited application of the LA Act in terms of section 26 of the BDA Act, the provisions of section 4 of the LA Act not applied to the under the BDA Act. Section 6 of the LA Act is not made of section of amendment 66 of the LA Act provides on issue of final to be authorized. We may notice that in the above case, the court declined to determine whether provisions of It's apparent that the decision of the legislature the decision will be directly stop the decision of the private banks. By indirect method of making a time frame, time period of 2 years of section 11A of the LA Act, mandate of BDA Act is violated. However, it is often that various decisions have been taken into consideration, particularly by the legal judge. However, whereas decision that has set the controversy at rest has not been noticed even by the legal judge or by the decision judge. If this is the fate of the law of the land laid down by the court, that too, the decision by the constitution so much can be taken, but to exercise restraint in the best use of the power. This state is better. The way in which the justice has been dealt with the planned development of the new city has been left as a mercy of different from the fact that single judge has relied upon the decision in the Petitioner's manner, in which it was observed that the decision scheme of but besides the question of time period, which was built upon, and what was ultimately decided by this court in absolute verdict, has been definitely
Tomorrow we'll continue. No, we are not saying that the timelines provided under Litigation Act apply and the proceeding will lapse to the BDA Act. We are not saying this for the list. We accept this. It's binding on us. We are not saying that it will lapse if it is not issued within 10 years. No, you need not labor on that. We are aware. We are not going. No, we don't have slightest misconception that it has to be done within 2 years. Otherwise, it will lapse because Section 6 says so within 1 year and 11A says no. Those timelines do not apply. Yes. List, yes. List for hearing tomorrow. List tomorrow. That's all.
Independence of the writ petition. Same order. Independence of the writ petition.
What number? 58. 58. Fine. Remaining cases to continue tomorrow in the list. Who appears? So he's paying for time. How much time? 60.1, madam. Mr. Basavraj Sabrat Lalit seeking counsel for respondent to entry. Praise fund is granted 2 weeks time to enable him to file objections. Yes, interim order granted on earlier occasions are continued.
61 kindly have it tomorrow, my lord. 61 kindly have
tomorrow. Yes.
61,
my lord, they are not
Yes,
served
yes,
the vacating
tomorrow.
IA, my lord. Maybe directed to serve the IA, my lord. 61, they are not served the vacating IA. Let them serve, my lord. Have it on next week, my lord.
59.
Kindly have it, I will serve, my lord.
Next week,
Kindly have it
kindly have
tomorrow,
it on
my
next
lord.
week, my lord.
Kindly have it tomorrow, my lord. I will serve.
Till date, they have not served, my lord. I will file objection also.
No, I
Kindly
was
have it
sent,
on next
but
week, my lord.
the office was
Monday
closed.
is enough.
No one
Monday,
was there
okay,
to receive the copy. It is for final hearing, my lord. Kindly have it tomorrow, I will serve.
Tomorrow.
Kindly have it tomorrow, my lord.
Yes, yes.
Lord.
59 what?
Kindly have it tomorrow, my lord.
I appear for the respondent in 59, my lords.
So Mr. Ramesh is saying, urgency. This is 2021. What urgency?
My lords, stays are operating against me, my lords. I am for the respondent.
I am for the implementing petition, my lord.
So next week, Mr. Ramesh, or what?
A date may kindly be fixed, my lords.
17th March.
Grateful.
Mr. N.K. Ramesh, Learned Counsel for the applicant, prays for short accommodation list on 17th March 2022. This is 59 March. 61 will continue tomorrow.
Kindly have it tomorrow, my lord.
Of course, tomorrow. Hey, twice we have told you, you are not still satisfied. What to do? Twice we have told you it will continue tomorrow. We can't do anything else. Yes.
ಇದರಲ್ಲಿ ಬರಿಬೇಕಲ್ವಾ